Let's bring this meeting back to order. Welcome back from lunch. The first topic for our consideration after lunch is going to be digital speech protection and immunity. Before we get going, anyone on the committee want to make any statements, have anything to say? Seeing none. All right, we're going to start with a little introduction to the issue by the Legislative Service Office. I don't know, is Ian, are you doing that, or Tamara's doing that? All right, Tamara, the floor is yours.
Mr. Chairman, members of the task force, I didn't think that this bill draft deserved a little bit of merit for the background and kind of orientate the task force about some of the concepts that went into it. So at the last task force meeting, there was a robust discussion about digital protection for digital speech and ongoing current events and how the courts and crime enforcement agencies were dealing with digital speech and code and computer programmers. And I understand that was a lively discussion, and what it resulted in was a fairly multifaceted motion that was made. And the motion covered things including to extend First Amendment speech protection to computer programmers and developers, provide criminal and civil immunity to computer programmers, and to limit obligations in Wyoming for persons who create backdoors to computer code. And I think it might have even went beyond that, but I think what this bill draft attempted to do was at least start addressing some of those concepts that came up during the discussion, and it's maybe something you want to build from, or maybe something we can make more broad to address some of the other ideas that were mentioned. I think that many of these issues are fairly complex legal issues, and so I do think this bill draft is really just the start to the conversation about how do we deal with these issues. And they're not easy, and that's one of the things that I think was discussed at the last meeting, is that our courts are coming out in different ways because these things just haven't been tested yet. And where they are tested, courts are looking to pass precedent and trying their best to figure out how to apply things that existed in the past to new things that are hard to legislate and hard to govern. So the first part of the bill draft is where I'll start, and that deals with the task force's request to extend First Amendment speech protections to code. Under the principles of separation of power of the Wyoming Constitution, we are limited in how much the legislature can instruct courts on how to interpret the First Amendment in certain ways. Really, the mechanism that would be to change the Wyoming Constitution would be a constitutional amendment. I didn't really understand that to be the direction of the committee, so gone with two approaches into the bill draft, which I'll jump into now. And so this bill draft is 20 LSO 55, working draft version 0.4. And what it does is create a new act in Wyoming statutes. It's the Digital Expression Protection Act. And we have some definitions at the beginning that I'll come back to. But the meat of the first part that I'm going to talk about is on page 4. The new statute would be 135-203, and a pretty broad statement: the digital expression shall receive the same protection from infringement by the state as any other expression of speech that is communicated through a non-digital means. So it's almost a statement of legislative direction to the courts that we expect speech communicated through a digital means is just like any other speech. And that may not be earth-shattering. That is probably how First Amendment jurisprudence currently stands. If it is communicated speech, it would probably receive protection. The other alternative that was provided is in the staff comment for you, and that was the concept is rather than trying to deal with how does a court interpret the First Amendment, it was to create a statutory right, which is modeled on Religious Freedom Restoration Acts, which create a statutory right that is separate from religious freedom under the First Amendment. And so you see that alternate language on page 4, lines 20 through 31, and continuing on to page 5. And what that would say is, in Wyoming, there is a new right, and except as provided in subsection B of this section, the state shall not infringe a person's right to digital expression. The circumstances in which the state may infringe a person's right to digital expression is only if it demonstrates the infringement in that particular instance is narrowly tailored to serve a compelling state interest and the least restrictive means of serving that compelling state interest. And that's modeled on strict scrutiny that would be used by a court in analyzing a First Amendment claim and other claims. And subsection C of that alternative language provides that a person whose right to digital expression has been infringed in violation of this act may assert a violation as a claim or a defense in any judicial or administrative proceeding and obtain appropriate relief, including equitable relief. So those are two options for your consideration. I think there was concern through the LSO internal review process that this alternate language might be beyond what the task force envisioned protecting, is really, we can't say to what extent it's going to protect all activity that's done digitally. It's a pretty blanket right to speak digitally, and really there's just not anything like it that I could tell you how a court's going to read that and how far it would extend to. But backing up on the bill, that was really the big first part of the issue, was how to deal with granting that kind of protection for speech that the task force discussed. I'll move back to the definitions on page 2 and address what we mean by a digital expression. This would be a new definition, and it would mean an expression of speech that is communicated through source code or a computer program. So that's fairly limited through two kinds of mediums, source code and computer program. And computer program, we've borrowed the definition starts on page 2. It says computer program means as defined in Wyoming Statute 63501. Well, 501 is the computer crime statutes that we discussed in the earlier bill draft today. And so we're borrowing that definition of computer program, which means an ordered set of data representing coded instructions or statements, which when executed by a computer cause the computer to process data. We're creating a new definition for source code on page 4, and that means a high-level computer language typically used by a programmer to compose computer programs. And so throughout this entire bill draft, when we reference digital expression, we are talking about speech that is communicated through source code or computer programs, in that limited sense. The next part of the bill goes to creating civil and criminal immunity. Begins on page 5, and subsection A that's created by this bill states that digital expression that does not otherwise constitute a crime or subject the person responsible for the digital expression to civil liability shall not serve as the sole basis for any criminal or civil liability based on the use of that digital expression by another person. Subsection B addresses hosting and storing digital expression, and it provides that any digital expression stored on a computer network, or computer system in Wyoming that does not constitute a crime or otherwise subject the person hosting or storing the digital expression to civil or criminal liability shall not serve as the sole basis for any criminal or civil liability based on the use of that digital expression by another person. On page 5, there's a clarification that this is not meant to be blatant criminal and civil immunity. It's not meant to make legal activity that is clearly criminal. So it states that nothing in this act shall be construed to limit or prohibit liability for criminal activity merely because the conduct was in part initiated, evidenced, or carried out by means of a digital expression. Finally, the last new created section would prohibit the use of state funds for the creation of a backdoor. It states that no funds of the state of Wyoming shall be used to compel the alteration of a digital expression for purposes of collecting or reporting information, the state or the United States government, including any of the United States government branches. And that is intended to be narrowly addressed to instances in which the state is attempting to compel the creation of the backdoor. It's, I think, was part of the motion that was made by the committee, and part of the discussion afterward was to limit the use of state funds for that kind of activity. Finally, I think Section 2 is just a severability provision. State that if any of this act is held to be unconstitutional, the remaining provisions of the act are still in effect. And it would be effective July 1st, 2020. I think I can stand for questions now.
Great. Thank you, Tamara. Committee, any questions on how the bill operates, what it does? Mr. Co-Chairman, go ahead.
Yeah, I just want to give kind of a comment in regards to this. This is one of those overly broad subjects that we kind of handed to LSO, like, hey, this is a really cool idea, run the ball. And this, we've done this over and over again for the last several years, and every time LSO delivers. So I just want to say kudos to you guys, because this is a big swallow, and I think you hit on most of it. Good job.
Thank you. Senator Nethercott.
Mr. Co-Chairman, to follow up with those comments to LSO on this, I have done a number of work in the First Amendment realm, and that is a bear. Legally, and it's very complex. And this is really good in light of the complications and the legal complexities and landmines of the First Amendment statute. So, great job.
Thank you. Anyone else?
Mr. Chairman?
Yes, go ahead, Ms. Long.
Thank you. Just for the task force's recollection, we were pursuing this in lieu of considering creating an express authorization for a new type of business entity that would have been controlled purely by code. I just saw yesterday that there's an article about a proposal for creating new business entities that are run by AI. So this is definitely a hot topic, and I would encourage the task force to approve this in lieu of creating a new business entity organization, because essentially this just takes the liability away from the developers. It achieves the same thing, the same result, without creating a whole new, opening the can of worms of a whole new business entity. This is broad, but I think appropriate, and I would concur LSO did a very good job. There may need to be some refinements. I was looking to Will here as the developer who's here today to try to refine some of the definitions, and I would probably, when we get to the point of working the bill, I think actually it may make sense to lay this back to September so we have a chance to really refine those definitions and get those right. But it sounds like the momentum is to support this, and I would concur. Thanks.
All right, any further discussion, committee? So we do have an issue that we're going to have to decide, and we can take public testimony on it, but I think it's worth discussing before we get to the public testimony, which is staff comment on page 4 and 5. And when the staff was discussing this with Co-Chairman Lindholm and I on which approach to take, we thought it best to just bring both approaches to the task force and decide which one seemed to work better. So there's effectively the broad digital expression shall receive the same protection language that we have as currently drafted, but bottom of page 4 onto page 5 incorporates language similar to what states have used on RFRA, which is kind of recognized as constitutional because, again, it's within gold standard, within states' rights to codify this way. But the question I have, which is kind of interesting for discussion, and maybe Tamara can start, but maybe others would be interested. Does this grant, as written, if we look at the staff comment language, the RFRA style language, would digital speech be more protected than non-digital speech with that because we have the explicit protection in statute, or not? And maybe the answer is not, because again, when you look at the B provision, it seems like that's standard case law with regard to protected speech anyway. So, Tamara, what are your thoughts on that? Would digital speech, if that language were our choice, be more protected than non-digital?
Create more expansive protections for digital speech. Any other speech, if it's communicated through paper, written medium, or expressive conduct that's communicated by actions and by putting on a display, the court would do a multi-level analysis. They'd look at whether the law that is infringing or the action that's infringing on somebody's right is content neutral. And if it's content neutral, it means it's not a prohibition on that specific activity in that sense. It's just a general protection for the don't start fires in this area kind of law. Then a lower form of scrutiny, intermediate scrutiny, would apply. And so the government would not have to show as much to have the right to regulate that activity. So this is, in fact, saying in any instance, it doesn't matter whether the law or the action is content neutral. We're going to create a statutory right to strict scrutiny for digital expression.
Mr. Co-Chairman,
Yes, go ahead.
if I may, my compliments to LSO. I just want to make sure are clear. Does not signal my support of the bill. Not quite sure how I feel about it, but I just want to recognize that the good work of LSO does not indicate my support of the bill per se. And if I can, and I think Ms. Long touched on that briefly, but what I'm really trying to understand here from a very practical standpoint is who this law is benefiting and why. And so, what are we trying to accomplish here?
Thank you, Senator. Anyone want to address that?
In
Ms.
a very real world scenario.
Yeah. Ms. Long, do you have anything to add? We'll get testimony on it. Go ahead.
Yep, Mr. Chairman, thank you. And Senator Nethercott, it is protecting developers. There's a reason why the vast majority of developers on open source projects do not reveal their name. And it's precisely because of the liability concern, including Satoshi Nakamoto, who created Bitcoin. No one knows who he, she, or they is or are or were, precisely because of concern about being prosecuted.
Thank you, Ms. Long. Follow up, Senator Nethercott.
Thank you, Mr. Chair. I get those kind of abstract concepts, but let's just take the example of him, whoever him is. But what would he have been prosecuted for theoretically, even? I mean, I understand the fear, but the fear doesn't mean it's realistic. And so a constitutional protection, any kind of digital code, any kind of communication would be considered speech. So we have our constitutional protections regardless of Wyoming state law. But I'm just really trying to get my head wrapped around the practical applicability of this and ensuring we're not creating a space for speech that Wyoming does not support potentially. And I'm not relating to his work, but how this could be used by the Ukrainians potentially and other actors in that sense.
Paul Long?
Yes, Mr. Chairman, Senator Nethercott, the concept here is separating out the use of the code for malicious uses as opposed to the code itself. The code itself being speech, and part of what prompted this was back in the spring there was a move by the federal government to start to include code itself as a prosecutable offense. And it started to appear in some of the FinCEN guidance on anti-money laundering and know your customer. And so it's interesting because the Undersecretary for Terrorism Finance spoke at the consensus conference in May about this, and they want to require that all code, including open source projects, include identification means for customers. And the Undersecretary's response when somebody asked the question and said, you can't force Bitcoin open source code to be rewritten to include that, her response was, well, that's your problem, or some words to that effect. So there's a really serious implied threat on the developers that they might be prosecuted for not including these restrictions. And all this does is say it's the users who use them inappropriately where the crime is happening. It's not the developers who are contributing code to the project who should have the liability. There's absolutely liability if you use code for nefarious purposes. And I love the way LSO drafted this because they put the critical word in here, which is sole basis for liability. And that implicit threat from FinCEN was that they would be using this as the sole basis to go after developers for criminal prosecution, for not putting those backdoors into the code. Hasn't happened yet, to be fair, but this was part of the impetus for the discussion in Jackson.
Follow up, anyone else in the committee? Yep, go ahead, Mr. Cole.
Also, the implication there is that they would be holding someone liable to do something that they can't possibly do. Like, they can't possibly build that into it through. So therefore, they'd be put up against an impossible task of complying with something that they simply can't comply with.
Thank you. Additional discussion. What was the name? I'm trying to remember the name of the program that decrypted the DVD originally, the region codes. I think that was what it was. That was then illegal to have the code itself for a temporary period of time. Then it was all on everybody's T-shirt.
Yes.
I know. Good story, right?
Yeah.
Yeah.
It also, Mr. Chairman.
The point though is that the code was illegal.
Right.
The code was made illegal at that point in time. A lot of people possessed it on a T-shirt. It was a commonly purchasable T-shirt for a while, since they were just making a mockery, and then posters all over the place was the response to making it illegal. But the code itself was made illegal, and then it was openly ridiculed and mocked to the point where it was unenforceable. But it was still made illegal. The code itself, not the implementation of the code. And I'll come up with what it was. Any other discussion on that before we take public testimony? All right. Seeing none, let's go to public testimony. And if anybody has any thoughts, we really didn't address or resolve the RIFRA style language versus the more general language. People providing public testimony have any thoughts on that? We'd appreciate hearing it, or any other. But at this time, we'll open it up for public testimony. Anyone want to weigh in? All right. No one weighing in on this.
Tired.
I know, it was lunch. I was a little tired.
It's like 90.
Yes. All right. Well, that will close public testimony and bring it back to the committee. What would we like to do with this one? Do we want to move the bill? Do we want to move it now, or do we want to take it to the September meeting? Is the question I was going to ask. And then vote on
not a final.
Vote on it or move it forward. Well,
we'll have a vote, but that way we got another crack at September.
you want to discuss some amendments and then leave it open effectively?
Yeah,
All right.
I'm getting rid of staff copy.
We're doing final votes at some of them. Yeah. To move it to recommend it to a standing committee, but we don't have to do that today. All right. So with that, let's talk about the bill committee. And it's probably going to end up at the Judiciary Committee. So
I know.
I hope by the end of it, Senator Nethercott is either a strong advocate or.
Mr. Chairman, I'm debating that. So I'd like the committee just for just to consider the concept of how this could be used nefariously. This safe harbor bill.
With the naughty consequence.
So if I could have the developers speak to how, if you wanted to use it nefariously, how you could, essentially. I mean, not you, of course, but the person in Ukraine.
Are you asking me to use my imagination here?
I am.
Yeah. No, I mean, I think just like anything else, you can work on open source projects that are bad and do illegal things. You could have a project like, any number of projects that have been Silk Road, for instance. Like the code for that could be open source, and just because it's open source does not necessarily mean that the developers working on it are, immune from any sort of scrutiny on whether or not they've been doing something wrong. The open source nature of it doesn't change anything at all. But I think this covers that, right? As long as it's not otherwise illegal. If you're looking for how I would, do something nefarious within the framework of this, I don't really know. I think if anything, it just gives me sort of the comfort that working on an open source project like Bitcoin, I could divulge my identity and not fear of prosecution. Did I even come close?
Senator Nethercott.
No, Mr. Chairman, I appreciate that. I mean, I admit in this particular, I think I understand what we're trying to protect. I hear the concerns of those requesting this level of protection, recognizing you're only protected from state prosecution from the fact that nobody's prosecuting you anyway, but nonetheless, I just see that the bill was drafted in a way to protect those who are doing lawful activity with lawful speech. But because hopefully none of you on the committee are criminal thinking or connected to organized criminal activity, you're not understanding maybe how the negative implications of this may come about. And I want to ensure that Wyoming is not naively creating a criminal safe harbor for somebody who's storing source code or for the creation of the next anarchist cookbook online, recognizing other nefarious purposes for which they utilize.
Yep, go ahead.
A question to Mr. Cole to maybe help advance this discussion. What if a developer wrote a deliberately malicious piece of code and contributed it to an open source software project and knowingly, deliberately did that, and then someone used it and lost money? That is, I think, where Senator Nethercott is going.
Go ahead, Cole.
I don't really know how to answer that. If they, my understanding of the way this is drafted is that that would be illegal activity anyway, right? And therefore they wouldn't be protected at all, right? If they knowingly did something nefarious to help someone lose money, that would be akin to writing malware, and that's not, protected. The circumstance that I'm thinking of is closer to, say, the developers who worked on Ghost Gunner or something like that, where the basis of prosecuting them, I believe, was that the transmission of the CAD files and the code that was written to do that held them responsible for essentially arms dealing, right? And that's sort of the distinction I would make between.
Well, what about, so as we're speculating things that would be protected, peer-to-peer file sharing, obviously prosecuted for a while on that because they were sharing media. So most of these peer-to-peer file sharing, the activity was illegal, but the code itself could be used for sharing media which is copywritten or sharing files, Word documents, whatever else. So with this legislation, pretty clearly in that instance, you have use case as the evaluator. Now go to something where there's no good use for it. Software is neutral. We'll say something that shuts down the power grid, local power grid. So hacks in, shuts down the power grid. It has no positive use case, unless you're just into shutting down power grids or whatever the case. But it's not. There's not a purpose that is a legal purpose for it. Is this then going to protect that individual that wrote the code so that they release it and they just say, look, we don't encourage anyone to use this, but we are protected, our speech, because we came up with the idea of how to do it. We wrote it well. Right. Something along those lines. Ms. Long.
Mr. Chairman, I think it does achieve that because of the word soul. This can't be the sole basis of civil and criminal liability, but you could certainly create other, in that instance, it would be breach of peace, theft of property.
It probably still wouldn't necessarily, because if I wrote a text, if I just sat down and wrote, this is how you would attack the power grid, that's already going to be protected speech. I can write that book.
Right.
So this is just saying, can I write the code? And this is saying, yeah, you could write the code too. And I don't know why we would necessarily delineate. So I mean, there are things that we don't like said that are still protected speech. We have to remember that. And this puts it on equal standing, where we would be saying, all right, well, it can be code that you don't like either, that is allowed to be written. If you're not intending to use it, if you don't use it, you're still going to be protected. So we have to be comfortable. Co-chairman, thoughts?
Yeah, thank you, Mr. Chairman. I guess going forward, if there is, if we need to strengthen the limitations on criminal and civil liability and ensure that we don't end up encouraging criminal activity, then I think there's merit there. But I do hear the concern that, I mean, for instance, the Anarchist Cookbook was legal to write.
And distribute.
And distribute.
But
Absolutely.
You're going to end up on a list when you download it.
0 fun times, I'm guessing, being on that list. I have never read such book.
Right. Not having any interest in cooking. Exactly. So, yes, Ms. Long.
Another example is Cody Wilson's 3D printing for firearms. I believe that the distinction has been made that the software itself is not the issue. It's people who download it and then take a step to use it.
Right.
That's where the crime took place. And that is, I think, the right distinction. The US government has historically blurred these lines. The crypto wars of the early 1990s, where cryptography was deemed math, in other words, was deemed munitions and was made illegal. And I believe that went up to the Supreme Court, and the Supreme Court said, no, that's speech. So this is consistent with the precedent of making the distinction between the code itself, which is speech and protected, versus the use of the code where you could get into criminal use. And I think that is important. Admittedly, we're only giving a state safe harbor, but we are trying to attract developers to move here. And
we won't prosecute.
Yeah.
Or as we see in the, well, that's the backdoor concept, but page 6, we won't use state funds to facilitate it either.
Chairman.
As a brief aside, the program was called DCSS, DE capital CSS, and yes, you can still buy the t-shirts if you want to. Senator, did you want to weigh in? You looked like you were reaching for the microphone. Good? All right. Committee? Anyone else? Matt, down there.
Mr. Chair, I just an observation, and I'm not sure that this thought is fully formed yet, but I'm applying a couple of real world examples I've had of some litigation and how I might apply this. And what I'm a little concerned about is, while I'm totally supportive of the idea of carving out some protection here, we're talking about both civil liability and criminal. And what I'm hearing in terms of the concerns is mostly focused on the criminal aspect. So I would really hate to create a defense in the civil context so I'll just give you the example that I'm using. I have a client that is a coding shop. One of their former employees misappropriated some trade secrets and is using that in another shop and drafting that code. Now, there's not necessarily a law that we can use other than misappropriation of trade secret to go after them. I would hate to see something like this be used in that context to say, well, if the sole purpose was or the sole reason for my liability stems from the fact that I expressed myself via this code, then it's a protection from civil liability. I don't know that this language does that. That's why I'm saying I'm not sure that this thought is fully formed yet, but I would personally rather see it limited to the criminal aspect and not the civil aspect. I think it's much cleaner. I'm also just a little bit confused as to why we have both and. On one hand, we're raising the scrutiny. We're raising digital expression now to the same platform as religious speech or something like that. And then on the other hand, we're also saying, and you can't be prosecuted civilly or criminally. It seems like we only need one or the other, and maybe I'm wrong on that, but I'm just not convinced we need both.
Interesting. Yes, Senator, another comment.
Thank you, Mr. Chairman. I think to go to some of those issues, this bill addresses three very significant concepts in the law. One is constitutional law. So state action infringing on your constitutional rights or your First Amendment rights is not a criminal action per se, right? They're not charging you with a crime. They're just interfering with your constitutional rights, which then presents a cause of action to you if that happens. Then two, we have the criminal concept that the government is pursuing you for a violation of criminal law as a result of the code. And then two, we have the civil law, which indicates that there would be a private dispute between two private people seeking monetary damages as a result of that speech, the use of that speech. And so all areas of law are connected here and all very, very complex. And I don't think we fully thought it through all of those pieces, particularly in the civil context between a private right. I don't think that's appropriate here. And again, conflating maybe the criminal concepts with a constitutional violation is also very, very different and probably going to end up in a bad result as a result of conflating those two very complicated concepts.
Other discussion?
So, Mr. Chairman,
Yeah, go ahead, Mr.
just to
Kaufman.
follow up on that, because
Yeah.
I agree with what Senator Netticott just said. And I think what I was getting at in my comment is of the three different things that this bill is addressing, my understanding is what we're most concerned about addressing is number two in that criminal protection. And so I'm just wondering if by focusing it only on that, we clean up a lot of the concerns of the bill and accomplish the goal of creating some protection criminally.
Other discussion? Senator Netticott, you want to weigh back in?
Yes, Mr. Co-Chair. If we look at that language on the criminal piece, it's superfluous again. Right, so page 5, line 10. Digital expression that does not constitute a crime. It won't be charged. That's good. I mean, I don't know that we need to put in statute that non-criminal activity will not be charged. And that's all it says, right? So I don't know that an actual protection is being provided in that sense. So I don't know the efficacy of the bill.
Other discussion? Yeah, it is a little kind of tautological there.
Mr. Chairman,
Yeah, go ahead.
one thing, if this did go through, one thing I'd like to be able to do is work on the definitions here, like source code, things like that, because if it did go through, there's a lot more than just literally the source code to be contemplated when if it is being protected, specifications, white papers, things like that.
Thank you. Other discussion? Yes, go ahead, Ms. Wong.
May I propose that a small group review this? It may not be what your co-chairman was anticipating, but I think we do need a little bit more work on this before a formal vote anyway.
No, I think that makes sense.
And propose that Mr. Cole, Representative Yin, who's also a developer, and maybe Senator Netticott,
Yeah, I think Senator Netticott,
and I'm happy to join as well.
that would be good. If what's you just want to go? What if what if you looked for the heart of it, the part that we love, and figured out a way to move that forward? I like that proposal. I think it's a good idea.
I think we can go ahead
For
and
the
move that.
discussion. Not do that one.
Yeah.
Yeah. All right. So
I just
Co-Chairman Lindholm suggested, and I think it's accurate, but we'll see if anyone in the committee objects. But without objection, I think the direction we'd want to go would be towards the language that's in the draft as opposed to the RIFRA language in the staff comment, so that we're not providing digital expression with more protection than standard non-digital expression. Is everyone comfortable with that as this little working group moves forward and works on it? All right, then for the record, let's have Senator Nethercott, Ms. Long, Mr. Cole, and Representative Yin work on an update to this draft
What you get not showing
for
up.
September 14th, yes. And if there's anything else that we could task Representative Yin with while he's in Canada, we'll definitely take that into consideration. All right, so any concerns, any further discussion on that action before we move on? All right. Good work on that one, committee.
A half hour behind.
I think we're ahead now.
2 p.m. hybrid digital assets.
All right, I think we're behind now. The next topic for our consideration is hybrid digital assets. We've got draft legislation to discuss. And let's see. We've had a good discussion about this from previous. Ms. Long, you want to give us do you have a second to give us a bit of background, and then we'll get into what the legislation does? But we've had a lot of conversation about hybrid digital assets. If you want to provide us with where we are on that.
Sure. Thank you, Mr. Chairman. This has essentially been brought up by folks who made the point that some types of digital assets may fall through the cracks and may actually be hybrids of a virtual currency and a digital consumer asset, for example. And it just may not be as clear. And that was the reason for asking LSO to draft this. This does change the recently updated taxonomy that we enacted last year, which built on the definition of utility token from 2018. Yeah, I think that's the background.
Great. All right, sounds good. Then let's walk through the bill a little bit, provided. And I think what we ended up doing, yeah, we have some cleanup language in here also, which is not necessarily just targeting the hybrid digital assets, but it's in the same part of statute. So Co-Chairman Lindholm and I had the cleanup language to Taxonomy Act last year incorporated into this legislation. And then we have basically the entire act here for us to take a look at in case there are other amendments that we need to make. So there's sort of two things going on here. One is cleanup language, and you'll see a lot of staff comments throughout that look at some of the cleanup language, and then a couple of changes that get at the hybrid digital assets. So with that, let's walk through the bill, and Ian, are you doing this one? All right.
Mr. Chairman, I'll do that.
The floor
Yes.
is yours, sir.
So that's correct. It deals with two kind of separate issues, because this bill, as it sits in front of you, has all the language that was created by Senate File 125 last year, and then suggests, as the chairman mentioned, some kind of cleanups to that, things that we could make more clear. Those I've tried to clearly indicate in bold language in this draft. So you're going to see statute headings in bold language, and then everything else in bold language relates to a cleanup to 125. Let me first address the substantive issue of the hybrid digital assets. As Ms. Long already indicated, the committee task force discussed last time a lot of the different nature of circumstances when a digital asset might not simply be a virtual currency or simply a security, but might cross those categories. And it seems clear. I did some additional research where, as always, we're on the forefront of this issue, but it seems that there are likely circumstances where it's not quite as easy to say it's going to be one or the other, but where it can serve multiple purposes. Previously, Wyoming law defines the different types of digital assets, says there's three different types: a digital security, a virtual currency, or a digital consumer asset, and then contained the language in 3429-101B, and this is on page 4 of that bill, that said the terms in paragraphs A2 through 4, which defines the specific categories, are mutually exclusive. Well, that basically says that it has to be one or the other and can never be a hybrid. So in this bill on page 4 on line 1, it accomplishes that purpose of creating digital hybrid assets by simply saying that the definitions are not mutually exclusive. That creates a hybrid by itself, just that simple language. The language after that then tries to define the rules that are applicable to a hybrid, because the question is, okay, so you have a digital asset that could be used as more than one variety. And this is honestly LSO's attempt at coming to a reasonable conclusion of what it might mean. But this was beyond a little bit of what the committee directly asked for. This says that a digital asset that constitutes more than one type of digital asset is subject to all the requirements applicable to each asset type to which it belongs, and then there's a qualifier, but only for the duration that the asset belongs to the particular asset type, and only for those transactions which qualify the asset in a particular asset type. So it attempts to narrow it only to the appropriate circumstances. That way, a digital asset that at one point is used as a currency isn't all of a sudden forever considered a currency. That might not make a lot of sense. That's the attempt to make those changes. On page 6 of the bill draft, you'll see some other language that's related to the hybrid digital asset issue. And that is the concept that if you're going to have a control agreement for a security purpose, for a security interest purposes, or if you're going to have custodianship of digital assets, then maybe it's important that there be an agreement between the custodian or the security holder about how they're going to treat that asset. And if they are going to take actions that would potentially make it into a hybrid asset or that would then make it subject to other laws, there needs to probably be an agreement to that extent. So there's a meeting of the minds. The language on page 6 attempts to accomplish that purpose. And then again at page 17, I believe, is the other, yes. And page 17, lines 5 through 8, again, that language says the bank and the customer shall agree in writing to any use of the digital assets that would subject the asset to a new or additional designations under 3429-101. It's kind of a consumer protection concept that if we're going to acknowledge that digital assets can be hybrids, and then we're going to subject them to other laws depending on what kind, if they shift in and out of a certain categorization, that the customer better be aware of that and they'll have an agreement to that effect. That is pretty much, the bill. That's a big concept, I think, and but it is fairly easily stated in statute. Again, we get to acknowledge hybrid digital assets by simply taking the word, saying that they are mutually exclusive definitions, and now saying they're not mutually exclusive definitions. It's a very easy legal change in the law. It's just the implications are fairly broad. At the end of this bill draft, LSO has outlined some of the issues that we discussed at the last meeting. Our discussion quickly went and demonstrated the variety of issues that this kind of a legislation raises. Let me see what else there is to discuss in this bill draft with regard to that. Mr. Chairman, I can then go on to the Senate File 125 issues if you want me to, but I didn't know if we wanted to treat them separately.
Thank you. I think treating them separately probably makes sense. Let's talk about the hybrid asset aspect right now, since there really are only 3 places in this where that comes up, and focus on that. Maybe take public testimony on that, and then go through the changes, and then work the legislation. Probably is the best way to go about it. Does anyone on the committee have a concern with that approach? All right, not seeing any. Then, focusing specifically on the hybrid digital assets portion of this committee, any discussion or any questions for that? All right, I have one. I think I have a sense of the answer, but when we look at the controlling agreement, or the control agreement, excuse me, so looking at the language on the bottom of page 6 and on page 7, it says the control agreement shall provide for any use of the digital asset for a purpose that would subject the asset to a new or additional designation. So, under a circumstance where you had a uniform digital asset, so it was subject to only one, it was not a hybrid, in its original state, based on this legislation, what would the process be to make that change if we didn't know when it was being created that it was going to potentially enter into another asset class. I think that's accounted for on page 17, but I just want to make sure that this doesn't preclude a change. We just need to make sure that there's the agreement in writing that that change is going to take place. So I'll ask and make sure that I'm understanding that right. Is that accurate?
Mr. Chairman, I think that is accurate. I don't claim to know a lot. People in the room know a lot more about transactional law than I do and might be able to better answer that. But right, I think that's correct. It says, I think it does contemplate that in the beginning of these agreements, your control agreements, you're likely going to contemplate any possible change so that you don't get caught behind the ball after it's used as a different type of asset. And this kind of language probably then forces your hand on that and make sure you do that. Again, this is language that wasn't specifically requested by the task force, but it seems a logical outgrowth of this kind of change. But it probably does put an extra burden on those who are forming that transactions to get that done beforehand.
Okay. But does it necessarily require them to, or would they just have the challenge of updating the agreement effectively, and that's going to be more arduous than having the terms and conditions set out initially?
Mr. Chairman, that's correct. It would not prevent you from later conforming the agreement.
Gotcha. All right. Committee, any other questions about the hybrid digital assets or concerns with the language? It seems to me that what we see on page 4, and this is something that Co-Chairman Lindholm and I talked through as this was being drafted, was it seems like the most reasonable approach that any asset class you have to adhere to all of the rules for that asset class. The moment you add, one little bit of a different asset class, now you have to take on an additional responsibility. And if you don't like that, don't add the additional asset class. Is everyone comfortable with that approach? Does it work? Yes. How would we know? What do you mean, Senator?
I agree with that logic, co-chairman. It's brilliant logic, both of you. But does it work in reality? I mean, does it prevent the transition? I don't know. I need somebody in the audience to say, does that actually work in reality? As opposed to, it's a good idea. Or are there naturally inherent conflicts with different types of assets to where you couldn't? And I understand that the consequence of that is that they can't both be, but then does that upend the entire concept? I don't know.
Good
The
question. Yeah, good question.
I think, Mr. Chairman.
Go ahead, Mr. Co-Chairman.
I think to some points we look at a hybrid asset. So say we're talking about what we used to call a utility token and a security token. Say it's a hybrid situation. Well, it's going to end up fulfilling all of the requirements for a security token at that point because utility tokens is considerably less. So it's kind of built off of the security token aspect. But I'll let the Secretary of State's office speak to this more pertinently, just sidebar conversations with them. They seem to think that the bill is decent, but I would be interested, much like Senator Nethercott, to hear from industry if they see that as a barrier. If anybody in industry has some kind of type of hybrid and they see a type of barrier to this type of language.
And we had some requests specifically for this to clarify that you could have hybrid assets. I don't know if any of the requesters are present. I don't think they are. But it is a good question to ensure that this is a workable approach moving forward. And I don't know if there are any conflicts between asset classes such that you end up in a situation where to conform with one, you would be failing the other, that they would be legally mutual. Question.
Mr. Co-Chairman.
Yeah, go ahead.
And maybe if that's the case, then they can't be that type of hybrid. It could be that simple of a logical result. But it would be helpful potentially to create a chart of the digital assets we know now and really visually see with creating that list where there could be inherent conflict, just to make sure.
You don't have them all memorized?
No.
I do.
Yes.
You do? Chicken.
Let's start charting.
Chicken free. All right. Any other thoughts before we go to public testimony? All right. Public testimony on, honestly, this aspect of it. We're going to talk about the hybrid digital assets, and then we'll get into the rest of the legislation. We'll have another opportunity for public testimony prior to working the bill. But let's talk about hybrid digital assets. Anyone from the public want to weigh in on the approach that we've laid out for providing hybrid digital assets? Yeah, we'll start with departments. If any department, Co-Chairman Lindholm suggests maybe the Secretary of State's office.
I mean, you can
Wayne, but
either
they don't
you can
really
either
seem
come up
to
on your
want
own,
to.
right? I'm going to force the issue. Sorry.
Yeah, sounds good.
Mr. Chairman, I
Go
don't
ahead.
think we picked on the Secretary of State's office at all this
I know,
session.
this is your opportunity.
Right. New
Yeah,
assignment
well, there
rules.
was this morning. That's
Yeah,
true.
I mean, we haven't like assigned any like new tasks or anything.
Thank
Welcome.
you, Mr. Chairman. Karen Wheeler, Deputy Secretary of State. And I do apologize, when you were asking the question, I was answering an email because we're moving Monday and we're having a little bit of a fire. This is what we're trying to put out. So were you asking if a utility token could also be a security?
Not, Mr. Chairman,
Go ahead.
not so much that, but if in this hybrid digital asset realm, if this legislation were in place and we had a utility token that, I mean, essentially had security token types aspects. I'm not saying, I mean, technically we theorize or our law states that if you don't follow this, boom, 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 then you're a security. That's it. Could there be a situation in the future where they meet both qualifications? And in that situation, would this be clear enough to your agency to be able to handle that situation where they had to cover both qualifications, which is essentially just the security token rate?
Deputy Wheeler.
Mr. Chairman, Mr. Co-Chairman, I think potentially you could have that situation in the future. And I'm not sure if this legislation is going to cover. So if you'll just give us a chance to go back, look at it, and make sure that it does. If not, we will bring an amendment to you. But I do want to make sure that we don't set anybody up for failure. So if we do have that situation in the future, we do have all the bases covered.
That brings up an interesting question about the asset classes having multiple regulatory entities, whereby adding another asset class, you might have one asset class that goes through our Secretary of State's office. Would we have asset classes that go through a different agency, or would they all go through currencies, virtual currencies?
No, Mr. Chairman, and I'm sorry to say this with the banking commissioner here, but you probably could involve his agency as well.
Yeah, I think we should. He's been shaking his head like, no, this isn't us the whole time. We'll get him up here too. Excellent. All right. Any other questions for Secretary of State's office? Thank you both. Appreciate it. Yeah. I think we should have the Division of Banking come up here and visit with us for a moment. All right. Send them. Welcome. Please tell us your name, sir, and welcome to the
Just for the record, just for officially, Chris Land, General Counsel, Wyoming Division of Banking and Department of Audit. It feels really weird and different to say that. It's a pleasure.
Yes, it does. Welcome.
It's a
Nice
pleasure
to see
to be before you today. So on the issue of hybrid digital assets, this issue was brought to us last year by Debevoise and Plimpton, the law firm, the Wall Street law firm. They were kind of building off some work that's going on in Europe right now. FINMA, the Swiss Financial Regulatory Authority, is looking at hybrid digital assets right now, and they haven't really. Oh, I should preface it by saying the new executive branch thing that I have to say that this is my own opinion and not the opinion of the Department of Audit or the Division of Banking. So going back to where I was, they haven't come down on. They haven't issued their hybrid digital asset framework yet, and there's some questions about what triggers the hybrid, what triggers the move to the hybrid, how it should be regulated, what's the intent of the parties at the beginning of the transaction, and how should that affect how the hybrid digital asset changes a little down the line. So there are a lot of issues to work out. the banking division won't be regulating virtual currency or utility tokens because, you know, the Secretary of State has utility tokens. They will be regulating securities, and we don't have any regulatory authority over virtual currency per se, unless it affects the safety and soundness of a bank. But I would like to caution the committee that the hybrid digital asset, when you have clean asset categories, it's a lot easier to regulate and a lot easier to know the characteristics of a particular transaction. You're trying to blend them together, it just gets a bit messy. So I'm really encouraged that the committee is taking on this topic. I just think that there are a lot of ancillary and collateral issues that need to be considered as well. So I'll stand for any questions.
Thank you, Mr. Land. Questions? Yeah. Representative Western?
Thank you, Mr. Chairman. Mr. Lane, just kind of out of curiosity, in terms of what would be the potential volume for assets on a transactional basis that would kind of fall into this hybrid category? I mean, I know blockchain and digital currencies and assets are emerging category and all that kind of stuff, but at least as of right now, do we have any sense of what that volume would be or why the statute is so important?
Mr. Land.
Thank you, Mr. Chairman.
Mr. Chairman, Representative Western. So this kind of goes back to the age-old question of why are people getting into Bitcoin right now? Is it a virtual currency? And a currency implies that it's a unit of account, a unit of exchange, or a store of value. People aren't using Bitcoin for those purposes generally. They're using it as an investment vehicle. And certainly people invest in currencies all the time. You know, you buy, or you short Hong Kong dollars at the moment because, you know, of all the stuff that's going on in Hong Kong, and that's an investment strategy that you're using through a derivative contract. But I think to answer your question, I think the market is rather significant. But I think when you take up the hybrid digital asset concept, you're kind of blurring the lines. It's easier from a regulator's perspective, and that's the hat I have on now when you don't have hybrid categories because you know what it is. It's either one of these things. From a federal perspective, the CFTC has come down fairly clearly. It says virtual currency is a commodity. The SEC thinks some virtual currencies might be securities, but most of them aren't. Digital securities are obviously securities regulated by the SEC. Utility tokens, the SEC doesn't like to use that term, first of all. That's the reason we're calling them digital consumer assets. But the SEC's position is their digital asset framework that was released a couple months ago actually incorporated a great deal of Wyoming's House Bill 62 amendments to the utility token law last year. So they believe now in somewhat of a concept of a utility token, but it's more limited than Wyoming's.
Additional questions? Thank you. Follow-up. Please feel free.
Thank you, Mr. Chairman. So the short answer is it's hard to put an exact number on it.
But in the context of Bitcoin as an investment vehicle for making money, it's potentially significant.
Pretty huge.
But you wouldn't need to classify Bitcoin as a hybrid digital asset to make money off of it. It's a commodity, and it would be treated as such, and you could still appreciate value. It's just not a security. Because
Ms. Long.
Chairman, Mr. Land, what was the issue the Debevoise attorneys were running into? Were there legal opinions they couldn't give because of the narrow nature of the existing definitions? What was the problem they were trying to solve?
Mr. Land.
Thank you, Mr. Chairman. Ms. Long, the issue they're trying to solve is FINMA, the Swiss regulatory authority, is considering whether hybrid digital assets should exist and whether it's a real thing or whether they should just be put into buckets. It's a very high-level theoretical discussion about whether hybrid digital assets are actually a real thing or whether we should recognize shifting or whether they should just be in separate buckets. The UK and Switzerland both have the same three asset classes that we have in our law, and they're trying to determine whether there should be a fourth or whether the hybrid thing is just kind of a... Now that I say that, kind of the fundamental question that kind of underpins all of this that I think you should consider is the reason people are talking about hybrid digital assets is because the technology and it hasn't been fit into the existing legal frameworks completely yet. That's the reason people are asking, can we shift assets? Some people want to shift between asset classes because they see an arbitrage opportunity, or they don't really understand how the laws work. Generally, Wyoming's tried to be enabling, but at the same time, people conform to the regulatory statutes that are set down. If there are 3 asset classes, a court is going to put the asset classes into the category that it most neatly conforms to. So, does that make sense? Does that answer your question?
A follow-up, Mr.
Go
Chairman?
ahead.
Mr. Land, do you think this issue is ripe? Or is this something we can take up maybe at a later date?
Mr. Land.
Mr. Chairman, thank you. Ms. Long, I'm not going to, that's the decision of the task force, obviously. I do have a call with the Swiss Regulatory Authority next week, and we're going to find out exactly where they are on their thinking on hybrid digital assets.
Other questions for Mr. Land? Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. Mr. Land, in regards to collateral issues, you spoke about that and named 0 collateral issues. Could you name some of those collateral issues?
Mr. Land.
Thank you, Mr. Chairman. Chairman Lindholm, could you relay the context that you were talking about, the collateral issues?
Yeah, Mr. Chairman, Mr. Land, we were talking about some of the issues that could happen because we define a hybrid digital asset. And you said there could be collateral issues that could happen because of that. So could you speak towards what could happen?
Thank you. Thank you, Mr. Chairman. Chairman Lindholm, the first one that comes to mind is the intent of the parties to the transaction. Obviously, under current securities laws, the economic realities of the transaction have to govern. But when you get into issues about liability and civil liability that, the issuers of a digital asset could potentially bring against the issuer, the purchasers could potentially bring a civil action against the issuer of the asset, the intent of the parties would come to bear then. That's one potential issue. So it's the intent of the issuers of the digital asset. If it shifts down the line, that the intent could be diminished. It would be Mr. Chairman, Representative Lindholm, am I confusing you? Sorry.
Mr. Chairman, I don't think confusing. I think the intent of the legislation is they have to meet both aspects in regards to the asset. So I guess I don't see that as a collateral issue because they wouldn't be switching from one to another. They have to meet both requirements. So because it's that dual requirements in place, if the regulating authority sees it as, listen, you're meeting both of these standards, you're technically a hybrid asset, they've got to meet both requirements. There's no swapping at that point, or at least the way I see it. Also, Mr. Chairman,
Go ahead.
Mr. Land, would you consider ERC20 tokens to be considered possibly a hybrid digital asset?
Thank you, Mr. Chairman. I'll take your second question first. Representative Lindholm, potentially ERC20 tokens are. As far as your first question, I think the intent of the parties to any transaction is paramount. And if they provide for both assets, it just confuses the intent of the parties. I can't say that I'm a Republican and a Democrat, for example. It's just inopposite. The whole point I'm trying to make is hybrid digital assets are kind of unprecedented. Hybrid asset classes are kind of unprecedented under financial property law, et cetera. It's we for better or for worse, and certainly this task force has the right to innovate as much as it wants to. I'm just saying that the whole idea that something can be two things or switch back between one thing or another is fairly unprecedented under finance. So,
Mr. Co-Chairman.
Yeah, thanks, Mr. Chairman. I guess Mr. Land, I don't see it in legislation where it says they can switch back and forth, and that's where I'm getting kind of confused. You keep mentioning that. I don't see it in there.
Mr. Chairman, on page 7, sorry, Mr. Chairman.
Go ahead.
Page 7, lines 3 and 4 provides that the control agreement shall provide for any use of the digital asset for a purpose that would subject the asset to a new or additional designation. That necessarily contemplates there could be different use cases and that it could switch back and forth during a transaction or between transactions or just depending on the use case.
I read that. Go ahead.
Mr. Chairman.
Yes, sir.
Yeah, thanks, Mr. Chairman. But there's the deal. If you go to page 4, lines 2 and 3, they've got to meet all requirements for each applicable asset class. So I guess maybe we need to do some cleanup language if it could be possibly interpreted as being able to switch back and forth, because I don't believe that is the intent of the legislation.
Well, I think, Mr. Co-Chairman, you've got the concept. We'll say it starts off as nothing but a virtual currency. And somehow it's a virtual currency. And then I change it so that it's virtual currency plus a security. So plus maybe a group of stocks or something. So my asset class would change. According to this legislation, the hybrid would then have to adhere to the original whatever virtual currencies we're adhering to. Now, the moment I add 1 share of stock, I've made my life difficult. Probably not worth doing it, but I did it. So now I have to simultaneously adhere to whatever I had to adhere to for a virtual currency, plus whatever I have to adhere to for a security. Perhaps I add other assets over time, but then if at some later point we'll say I drop my virtual currency so that I'm no longer holding any virtual currency, even though my initial statement, my initial agreement was I had virtual currency, that was the basis of it. Now I only have to adhere to securities law for whatever this object is. I'm no longer hybrid, I'm in one category. So I've gone from single category to hybrid to single category. I've made those transitions. I have evolved over time. And this statute lets you do that as long as you provide fair warning and have an agreement in place. So you have to have a transaction take place to allow for that. Unless it was assumed in the very beginning, I think that could be allowed. But then one question that begs is if it's assumed in the beginning that I'm going to be able to do virtual currencies and securities, but I hold no securities, am I a hybrid asset, or am I only going to have to adhere to virtual currency based on how this is written? Yes, go ahead.
Thank you, Mr. Chairman. A couple other points I want to make, and I would also highly encourage Ms. Long to chime in as appropriate.
Sorry.
The settlement mechanisms for commodities versus securities are very, very different, and in some ways they conflict. You can have physical settlement of a commodity, and the settlement method for a security is, someone at the depository trust company pushes a couple of buttons, and you have a claim to a security somewhere. So, like, the settlement mechanisms are very different, and in some cases might be conflicting. Yeah, that was the point I was trying to make.
So you may not know this, but perhaps you do, and Mr. Kaufman has a question, but quickly on that point. If right now I have a mix of commodity, a bunch of commodities, some currencies, a few currencies, and some equities, and I've got them all conflated into one fund, how is that currently governed, and how would it be settled?
Mr. Chairman, that's fairly advanced financial markets issues that I don't think I've ever dealt with. I don't like saying that I don't have an answer to something, but I will use that this time. The other point I was trying to make, Mr. Chairman, is that the federal financial markets regulators really dislike no. Actually, we talked to the SEC last week. They're probably listening right now. So we have a great relationship with the SEC.
I'd like to say hello, a shout out to the SEC.
Yeah.
Welcome to Wyoming.
Really like those guys. They're great.
Anyway, continue, Mr.
No, the point is, they look to the economic realities of a transaction and not what we call it under law. So the fact that this bill could permit hybrid assets might cause them to place less emphasis on what Wyoming's law says and look more at the economic realities of the transaction.
Interesting. Mr. Kaufman, you had a question. Sorry for the delay.
No, actually, that worked out perfectly, Mr. Chairman, because my question relates to that classification of how most often regulators look at a transaction. And I guess my question, Mr. Chairman, is the problem we're trying to solve seems like we addressed it already last year in the Financial Technology Sandbox bill, in that there's already flexibility for someone with a new financial product to essentially, right, try to get the blessing of some regulators. I know it's not a permanent solution, it's only a temporary solution, but we're sort of guessing at what these problems might be, and ultimately we're trying to anticipate how a regulator is going to look at an asset classification that we don't even know what it is yet. So I'm just wondering from the Banking Commission standpoint if it's easier to wait and see how this plays out.
Thank you. Any further discussion, committee, or questions? All right, seeing none, thank you, Mr. Land. All right, any other agencies we want to bring up? See anyone else you want to pick on out there?
Yeah, well, I'd like to know.
Yeah, all right, oh, we're opening up to general public testimony. Please come on up. And for the record, say your name once again, and welcome back.
Bob Cornish, Anderson Kill. We were talking about the unissued securities of a hybrid or a utility asset. Chris, I just don't I think some of us probably have seen this, but last week the SEC in a consent order suggested that unissued securities in a SAFT, in a SAFT agreement, even though people were arguing, of course, that the SAFT itself was a contract and the securities were to be issued at some later date and were never issued. The SEC nevertheless found that the SAFT, that those securities that were supposed to have been created and that were promised to people were indeed securities for the purpose of enforcement of registration and anti-fraud provisions. So in terms of the hybrid asset conversion of something saying that I am a utility token right now and maybe down the road people are buying in the PPM, there's a disclosure that says in the future this vehicle may convert into a security.
And it's a security.
Right. Now this is just what, I mean, there's been several commentaries on this. It's called virtual health. So it was a consent order that was entered last week. There's a lot of people who are going back and forth about this as to whether this is really the correct reading of how SAFs and tokens that convert, or even starting to get into the whole world of things that convert, like a convertible bond or a convertible debenture, things, how these things generally work. So to the extent that you are looking to create this hybrid structure, I think for purposes of this, of the securities laws, I'm not entirely certain you may be able to get out of them for a while, just because, frankly, the SEC at this point seems to have a different view of it.
Thank you. Any questions for Mr. Cornish? Seeing none, thank you, Mr. Cornish. Additional public comment. Going once, going twice, gone, public comment is closed. All right, so that was the hybrid digital assets aspect of this. Committee, we've got the rest of the bill to go over. Does anyone want to weigh in or discuss before we hear about the rest of the bill, the correction?
Yes.
Go ahead, Ms. Long.
Mr. Chairman, thank you. Could we talk about the staff comments? I think there are some of these that do need to be talked about before we work the bill. On page 8 is the first critical one.
Oh, Ms. Long, that's what we were going to go to next, actually.
Oh,
was
I'm
the
sorry.
staff weighing in on that. So just anything on the discussion we just had about the hybrid aspect, the digital hybrid digital assets you want to raise right now before we go to the rest of the bill?
I was initially in favor of it, but I'm convinced that it's not right.
Yeah, that's kind of where I'm at.
Yeah, and it may create a worse situation than we have. So
that's pretty much sums up where I'm at. Yes, Representative Western.
Thank you, Mr. Chairman. Actually, my comment is entirely unrelated. I just want to acknowledge real quick Miss Wendy Smith, who just walked in. She's an administrator here at the college, and she's kind of the big cheese on campus, and she does a really good job in making this place function and for hosting us here. So just wanted to acknowledge her real quick. Thank you, Mr. Chairman.
Thank you. thank you for hosting us. We really enjoy being here, and we appreciate the opportunity to visit with the Sheridan community. Further discussion on this? All right. Well, we'll get back to that as we work the bill. But with that, let's transition to the rest of the bill. Mr. Shaw, the floor is yours.
Mr. Chairman, these are the issues that are identified in bold type throughout the bill. I believe the first one is on page 6. And these are suggestions that LSO makes that have not been requested by the committee at all. And just let me tell you that up front, that, some of these might provide some clarification to what we addressed, created in House Bill 25 or Senate File 125, but certainly I don't identify any of them as critical or, necessary. The first one on page 6 on line 5 simply would add to the title of section 103 the fact that it does acknowledge control agreements, because as we've had Mr. Cornish presented last time and other people have talked about these control agreements, and they're a big part of what is required. We would acknowledge that in the title. On page 6 on line 20, the word also in that sentence appears to be not necessary. It's simply a matter of cleanup. It's, again, I don't think if the word remained there, it would not be fatal to the meaning of the statutory section. You move forward to page 8 on lines 15, and then this related staff comment to that. Maybe Ms. Long has some comments about that. That was just a matter of whether or not that language is necessary, as explained in the staff comment. I wasn't sure whether it confused it and whether it might be better to omit that language, but I look forward to some comments on that topic. Moving forward to page 10, stretching on to 11, I think there are two different issues that are addressed in the staff comments. First one is just from a structure of the statutory law comment. This provision provides a authority to the banks that normally, I believe, would go in the banking statutes. The reason it's here is because it deals with the bank's ability to do custodial services over digital assets. But on the other hand, the banking statutes currently grant to banks a number of custodial type opportunities that are then put in the banking statutes. Again, I don't think it's fatal either way. I believe Faulkner was going to look at that. I don't know if he has an opinion now, but I did ask him to consider that as well, whether he thought that was appropriate. And number 2 on page 11 is simply when I first reviewed this part of the statute, and in subsection A, which is on line 19 on page 11, says a bank may provide custodial services. And then you go to subsection B, and it says a bank may serve as a qualified custodian. And then there's a number of provisions that talk about federal compliance, and it appears to be related. And when I read the statute, I wasn't sure that there was if it's the task force's intent to make a more firm correlation between compliance with those federal regulations and the fact that this provision should be interpreted such that compliance with these provisions then would qualify you as a qualified custodian. I thought that language could perhaps be made more clear, and I made some suggestions in that staff comment. Moving forward then, on page 17, I believe, is the next comment. This is simply, and I confirmed with the banking division as well, on subsection N, it says banks are not subject to the annual reporting license tax levied under 1716, 1630. And it says in lieu of this tax and to offset the cost of supervision, and it imposes a new tax there. The problem is that the existing statutes make clear that banks are not subject to the annual reporting licensing tax, and therefore to say in this statute that then in lieu of that tax is a bit, if statutes can be ingenuine, then this one is, because they weren't in the first place subject to that tax. So I thought that it may be appropriate to delete that language. And on the next page, page 18, above the staff comment there in the bolded language, it says banks providing custodial services outside of this section shall not be required to pay this supervision fee. The question I had what about those banks who may be providing some custodial services under this provision and then some custodial services outside of this provision? That would make you believe that maybe there's not subject to any tax, when in fact you might want to proration that tax according to what services are being provided under which provision. On the following page, I think is the last comment, it talks about jurisdiction of the courts. It's the simple concept that this provision, when drafted, simply says that Wyoming court shall have jurisdiction. It might be appropriate to limit that to make sure that it can't be interpreted that every court has jurisdiction over all subject matters that would fall under these digital asset provisions, and rather I've suggested language on lines 24 and 25, subject to other jurisdictional limits placed on specific courts by Wyoming law. You know, jurisdictional monetary limits, et cetera, might be appropriate for the task force to consider. That's it.
Excellent. Thank you, Mr. Shaw. Representative Western?
Thank you, Mr. Chairman. Also, really quickly, the Sheridan County Clerk and Recorder is also present, and she does a really good job of making sure that our legal recordings here in the county are shipshape and all the T's are crossed and I's are dotted. So I just wanted us to recognize Ms. Thompson real quick. Thank you so much for coming.
Thank you, Representative. Welcome. All right, any discussion? Well, I think we should probably proceed through each of the points, one after the next, and discuss them as a committee, decide whether we want to take action on them, leave things the way they are, and sort of work through it if the committee is okay with that approach. On each of them, yeah. So you want to do them one at a time, or do you want to bring them up? All right, that sounds good. No, well, we don't necessarily need to move the bill. I think I just want to discuss each of the points. But yeah, let's do public comment from our agencies and hear from them on the various points, actually, as the co-chairman just suggested, and then kind of walk through it. Okay. So with that, let's call up the Division of Banking. I know the Division of Banking has some thoughts, hopefully, on this. We can bring them back up. There's a couple of these specifically relevant to you. Come on up. All right, a few of these were addressed specifically to you.
Mr. Chairman, Albert Faulkner, Banking Commissioner, and just to gloat a little bit, yes, it was a very good hire. The gentleman sitting next to me, so for the record.
Yeah, took the pressure off of you at these meetings a little bit, didn't it?
Yeah, Mr. Chairman,
Go ahead,
not
Mr.
everybody's thrilled about that.
Yeah, well, I'm glad he's finally saw what it takes to unwind everything that you all do.
Mr. Chairman, we've been on a bit of a roadshow. If you'll permit us, I'll share that with you briefly. We've been on a bit of a roadshow the last couple of weeks. We appeared at the CSBS legal seminar 3 weeks ago, and we spoke a little bit about fintech. But the main thing was 2 weeks ago we were in Washington D.C. for a week. We met with all the regulatory agencies, House Financial Services, Senate Banking, the Board of Governors, and we have a saying that I made the mess and now I get to clean it up. So yeah.
Nice.
So just in a joking way. So just some comments. Let me get there. So on page 8, staff comment on lines 17 through 21. The reason the language authorized by the secured parties there is because a multi-signature contract necessarily has multiple parties to it, and that language authorized by the secured party is to clarify that the debtor doesn't have a right to either request a multi-signature arrangement or to be the key holder to one of the multi-signature arrangement keys. Let's see.
Yep, 1 second on that point, Ms. Long.
Thank you, Mr. Chairman. Can I follow up, Mr. Land? Why is that important? It goes to the exclusive control?
Mr. Land.
Thank you, Mr. Chairman. Ms. Long, one of the issues that the Securities and Exchange Commission's commented on, and they think is one of the biggest issues with digital assets, is proving that you have exclusive control of a digital asset. You have a private key, but how do you prove that no one else has a copy of the private key? How do you prove you haven't been hacked and someone has hacked the private key out of you? How do you prove that you don't have a multi-signature arrangement? So in this context, we had to specify the secured party is the only person that can enter into a multi-sig, and the multi-sig would be totally within the secured party, or a fiduciary or a trustee of the secured party.
Ms. Long, follow up? All right. Anyone else on this point? Seeing none, please continue.
Thank you, Mr. Chairman. On page 11, page 10 and page 11, Commissioner Faulkner and I discussed this before we stepped up here. The reason it's in Title 34, Chapter 29 is so the definitions of digital asset apply to the custodial services section. So there's some context about what the qualities of the digital assets are when you're reading the custodial services section. But that could go either way, but I think the definitions provide some context to the reader. They're trying to figure out what's going on.
Okay, so Division of Banking is comfortable with where it's at now, as opposed to, I mean, we just redid everything in banking, obviously. Last year,
The trust laws, yeah.
But you're comfortable with this? All right, thank you.
The second staff comment on page 11. This is a tricky issue. The custody rule is federal law, and we can't in Wyoming say who is a qualified custodian and who is not. That's a matter of federal law. We don't really have legislative authority over that. So that's the reason there was no intent to require someone to be a qualified custodian. It was meant to be an enabling opt-in regime that if someone wanted to potentially have a greater chance of being recognized as a qualified custodian under federal law, that they would have this framework to opt into. So the thinking behind that. The next one is on page 18. Page 17. Sorry, Mr. Chairman. Page 17, line 16 and 17. I agree with the staff comment there. That appears to be a bit of commentary that may or may not should be in the statutes. That's up to the task force, obviously. Page 18, lines 4 through 6. The way it's drafted is correct. Unless you opt into the custodial services regime, you are not required to pay the supervision fee. And that's kind of that's if you want this added legal certainty, you have to pay the supervision fee. If you want to provide custodial services outside of the regime that's been established, you would not be required to pay the supervision fee.
And Mr. Chairman, if I could follow up on that also, so that'd be consistent with the existing practice right now. So banks through the trust department or trust and non-depository trust companies can serve as custodian of other assets, and there is no additional fee with the type of activity. And so then you throw in the digital asset spectrum as far as non-qualified custodial activities. Again, this would be consistent with it because they're not opting to the higher regime, as he said, the legal certainty. So therefore, there's no need for, in our minds, any sort of increased supervisory fee.
I think the concern was more the way the language was specifically written, where you could have multiple provisions of service. You could have a provision of service that is within and one that is outside of this section. If you do both, because this is a shall, you may have gotten yourself off the hook for paying, since you simultaneously are doing something which is a custodial service inside and outside by letter of law. So I think your intent is clear, but I think the concern that staff raised was this language provides you with a loophole to get out of it.
Mr. Chairman, we'll chew on that a little bit, but I think in either Mr. Land or potentially Ms. Long may want to talk. So part of when we were drafting the custodial rules based on Senate File 125, we've had a number of discussions around that, whether can you do part qualified custodial activities and non-part qualified custodial activities, and a number of times it mentioned that, and let's correct me if I'm wrong, to determine that no, you're either opting into the regime or you're not. There's no middle ground of that, because the question is, how do you regulate that? How do you supervise it? How do you determine what parts fall under the QC regime and which parts don't? I think it'd be almost impossible to adequately supervise that, and it also allows for potential gaming of it, and this might be an example of that. But
what if it were simply to say banks providing custodial services not within this section, or something along those lines, or only, or banks not providing custodial services within this section? So reversing it to clarify, you cover all of the above. Is there a concern there as alternative language? Go ahead, Mr. Land.
Thank you, Mr. Chairman. I don't think so. We could also put this in the custody rules too. They haven't gone up for finally adopted yet. Very close, but either way.
Okay, thank you.
The rules actually, sorry, Mr. Chairman, the rules actually might make it out before this bill does.
Okay.
Yeah.
Mr. Chairman?
Yes, Ms.
May,
Long.
may I follow up and ask, does it make sense, because we have had confusion on this very issue about whether a legal entity could be both a qualified custodian and a non-qualified custodian? Does it make sense to actually add clarification that it is either or? Practically speaking, Mr. Chairman, we determined in several conversations, it is impossible to be a hybrid because the qualified custody rules require enhanced audit of the organization. So you really can't have part of your organization have enhanced audit and then part of it not, right? So it is kind of an either or. And maybe we could clarify that, or do you think that it doesn't need a clarification?
Mr. Faulkner.
Mr. Chairman, Ms. Long. So to answer your question, yeah, there probably could be a way to do it. I think what we're starting to then transition to is a different discussion of what this bill is, envisioning, and maybe that's a different piece of legislation to clarify that, and because this is housed under the hybrid digital assets, and I think we're now going to be, while the comments are still pertinent, and they're pertinent whether it's outside of the hybrid digital asset discussion, and so maybe that's something we want to consider, and cleaning that up. But to answer the question, maybe there is some certainty there. Again, on the fly, I'm not going to opine as to how we do that. I'm not quite sure what that is. As Ms. Long knows, there was a pretty solid working group that we put together that gave a lot of comments in. So maybe that's a question we throw back out to them if there's uncertainty to it. Not quite sure.
Is this language, is this sentence obvious? Does it even need to be there? What happens if we take the sentence out? Curiosity, because you've got it elsewhere in statute. Mr. Lamb. Or do you not have it elsewhere in statutes?
Mr. Chairman, no, not specifically. I don't think it's elsewhere.
It wouldn't cover it elsewhere.
Mr. Chairman, the closest you come is page 17, lines 19 and 20. A bank which provides custodial services under this section.
But yet, doesn't that say it? I mean, that's you're basically just reversing it and saying if they don't, they shall not. If they do, they shall. Should suffice. That gets at what I said a minute ago, where you don't need the exception language if you're just saying under the circumstance where you are a qualified custodian under this, you have to pay the fee. We don't usually, you think about the rest of the legislation overall.
Yeah.
We don't say it both ways. You have to pay a fee for your license. If you don't have a license, you don't have to pay a fee. I don't think that happens very often in statute.
I think you're on point, Mr. Chairman.
Okay. Maybe we'll just take that out. All right, thank you. Page 19.
Mr. Chairman, that's outside the Division of Banking's wheelhouse. That's more of a subject matter jurisdiction area for the Judiciary Committee.
True stories. All right.
Hopefully not,
right.
Mr. Chair.
Any further questions for the Division of Banking? All right. Seeing none, there's been a little request that we take a 10-minute break, so let's do that. 10-minute break. And then we'll come back and take some more public testimony. black iPhone turned in. This is anybody's. Have it over the desk. I don't know. Yeah, it's
Apple. It's an Apple.
It's an Apple. There we go. Is that yours? All right, there we are.
Hackathon.
Got that sorted? Yeah, it's probably secure. We don't know. All right.
Cryptocurrency.
So we are still on 20 LSO 128, working draft 0.4. We're on public testimony. We just went through Division of Banking's views on some of the cleanup. And with that, I'll open back up for additional public testimony if there's anyone else that wants to weigh in on any of these little amendments. Any further public testimony? Seeing none, public testimony is closed. Committee, what's your pleasure? Mr. Co-Chairman.
Move the bill.
Bill has been moved. Is there a second? We need a second to clean up the errors.
Second.
There we
Thank
go.
you.
We've got a motion by
Mr. Chairman.
Co-Chairman Lindholm and a second by Representative Olson. All right, Mr. Co-Chairman.
Thank you, Mr. Chairman. I would definitely accept a friendly amendment if I get this wrong, but I would like to adopt the staff suggestions that are in the latter portion of the bill, except for on page 8, line 15 and 16, where the suggestion would be to strike that language. I want to keep that language in, the authorized by the secured party portion, due to the reasons given by Division of Banking. And that would be my motion. If I have a second, then we can discuss adding or editing.
I'll second, and then we'll let's march through a little bit because I
Ms.
think
Long.
some of them are a little different. Go ahead, Ms. Long.
Thank you, Mr. Chairman. Yeah, I think we do need to talk about a couple of more of them.
Yeah, let's walk through. Maybe, Mr. Co-Chairman, why don't you withdraw your amendment? We'll just walk through and do them one at a time.
Sounds slower, but sure.
All right. We'll try and do it quickly. Most of them will just be accepted. First of all, everyone understands we're not going to work the hybrid asset aspect of this, so we'll withdraw that from the bill. Yes.
Yeah, Mr. Chairman, actually, my motion on this bill was to adopt the whole bill. And the reason why I want to keep the hybrid digital asset ideology alive, I just want to keep it alive for a little bit until we hear back from the Division of Banking after their conversation with the Swiss bank, I think it was. So once that happens, I'll make the motion to remove the hybrid digital aspect or portion of this bill. But until that happens, I don't want to pull something that we could.
Well, here's a great idea then, Mr. Chairman. What if we just lay this bill back to the next meeting?
So moved.
Any objection to it? Without objection, we'll lay this bill back. As a matter of fact, we might find some other things to clean up in this legislation. I think we all kind of know where it's at. Any objection to laying it back to the next meeting? Seeing none, this bill's laid back. Yes.
Okay, if LSO separates the cleanup provisions from this bill into a separate bill, so in case you want to go forward with one and not the other, then you have two clean bills to work with.
Absolutely. Let's do that. Yep, thank you. All right. And staff, you heard the comments certainly on the cleanup, and I think understand that some of those cleanups are better than others, so we'll be ready for that. It was perfect. Well done. All right. Let's try and see if we can accelerate the next couple of topics. Next topic for our consideration is representation tokens. We've got a review of draft legislation, 20 LSO 152 version 0.4. Who's going to work that one?
Mr. Chairman, I can start the discussion on this.
All right. Mr. Shaw, you're up.
Hesitate to say this one will be faster than the last one. The only reason I say that is because I think this is a rather complicated issue. And I'm sorry, I misspoke when I was summarizing the last bill, because it is this bill, in fact, that on the last page, on page 7, does discuss some of the complexities that we discussed at the last meeting. And those deal with, this bill basically contemplates whether digital tokens can be used to represent, or how the use of digital tokens is used to represent underlying assets. And the task force had a couple of goals in mind and conveyed those to LSO. One was simply to acknowledge that what's called digital representation tokens exist in Wyoming. Second one was to declare that they are not separate assets apart from the assets that they represent. And finally, there was a request that it would allow special purpose depository institutions to specifically issue these representation tokens. A little comment about the name, digital representation token. It was unclear. We used a couple different terminologies at the last meeting to describe what these are. The word digital pass-through was used, as well as digital reserve tokens. LSO picked up on the name given here, digital representations tokens, just because it seems to be descriptive and adequately convey the fact that these tokens are simply representations of their underlying assets. If the task force chooses to use a different name, that's no problem. We could substitute that throughout the bill. On page 2 of the bill is the first, it accomplishes the third of the topics I discussed, which is to allow special purpose depository institutions to issue these varieties of tokens. I will come back to that language in a minute because I think it's maybe best to go to the meat of the issue, and that is, what is a digital representation token? On page 4, we adopted a definition. A digital representation token means a digital representation by which a person's claim to an interest or right in real or personal property is evidenced. That's a fairly broad definition. It simply encompasses all different types of digital assets that would underlie the token, all real and personal property. We move on to 3429.102. Again, that's the provision we've been dealing with in other bills that talks about the types of digital assets that exist. This would add a new paragraph 4 that would do two things. First of all, it would say that digital represent tokens are not a separate asset from the assets that they represent. And then it would subject them to the obligations and rights of the underlying assets and not to any other asset. This is similar, very similar in concept when we talked about private keys. Talked about the private keys are only subject to the rights of the underlying assets to which they give access. Here's the same kind of idea, that these digital tokens, representation tokens, are only subject to the obligations of the underlying assets. This really is the same. The language we used is on that page. Digital representation tokens shall not constitute real or personal property separate from the rights or interests in real or personal property that they represent, and shall be subject only to the obligations, rights, and interests applicable to the rights or interests that they represent. I give the same caveat on this bill that I did the last, and that language, while complicated, seems fairly straightforward, and it adopts a fairly clear standard. The question, I think, that for the task force is the actual complexity of a digital token is equal to the complexity of bazillions of different types of assets that it might represent. And again, on the next page, on page 7 in the bill, I talk about, or at least list some of the topics that came up last time. But it's the idea of the task force that, for example, asked for LSO to consider establishing that control of the token would equal control of the underlying assets. And while on a lot of different ways that makes sense and would be possible to do, to draft a single statement of control like that might very well ignore the fact that all the different assets, I mean, if you're talking about one for a security interest, or if it's virtual currency, or if it's property that's the underlying, those are different kind of assets that really may demand a different kind of treatment. And they also may demand a different a change to the existing law that is as broad, again, as the different assets that might be represented. And it's a bit of a daunting task when you start considering the different complexities. And I think the task force that's not unknown to the task force. That was really part of what I think we heard in our testimony last time. But nevertheless, LSO just wants to let the task force know that what is here is the very, it's the bare bones of the concept, that the representation token is only as good as the asset it represents. But that's a simple statement with a potentially huge number of implications.
Well said, Mr. Shaw. All right, discussion on this. And just to remind the committee, one of the things that we talked a lot about at the last committee meeting when we were proposing drafting this legislation was something like a piece of art, a work of art that's hanging on the wall, where you've got it tokenized for the ownership of it. That token represents some type of contract that's effective for the ownership, so you can have a 12% stake in a certain piece of art, because it's ownership of property represented by this token. So that's kind of the concept of what we're getting at and how it can be managed, but we went into a lot of details about other strange things. Some of those are listed on page 7. Fungible goods are a great example, maybe something which is not permanent, non-permanent property, assets like fiat currencies, if it's being backed by that. You've got a lot of nuance here. I think it's, once again, incredibly well drafted on page 5 and onto page 6 as far as the language that's being used to try and describe it and clarify. But with that, committee, any further discussion before we go to public testimony?
Mr. Chairman?
Yes, Ms. Long.
I'm going to make a pretty strong statement against the proposed changes on page 2 because since the Jackson meeting, we have had a lot of conversations with regulators and have a much better understanding that having the SPDI have the ability to issue its own so-called stablecoin would probably jeopardize its approval by the Fed. So there is a different structure. A number of people have come forward to look at using the Wyoming laws for stablecoins. There is a way to do it that doesn't involve the SPDI. It involves a statutory trust. So I think before we even ask the banking division to comment on this, I'd like to make a pretty strong recommendation that we not consider adding this language because it would jeopardize the master account application for an SPDI.
Okay, thank you for that. Further discussion, committee, before we go to public testimony? All right, seeing none, let's go to public testimony on this legislation. And Mr. Co-Chairman, what I was thinking with this legislation, and I think we've got a couple of other bills that are similar, digital identity, for example. This is one that I think we should keep open for the next committee meeting, talk about it today, take public comment. We don't necessarily have to be exhaustive today and work the bill. Then we'll have another opportunity at the next meeting to work this legislation to take more public comment because I think it's a complicated piece of legislation. What are your thoughts?
Yeah, Mr. Chairman, I generally agree that we should move it forward to the next meeting. With that in mind, though, if anyone in the committee would like to work the bill, then I highly suggest it. If we've got a situation where possible language on page 2 could jeopardize master accounts, then I would, once we get done with public testimony, I would definitely push
Take it
forward
out,
moving the bill, working it, and just shoving it on to the next one.
Okay, sounds good. Redraft, basically. Yeah. All right, sounds good. Any further discussion? All right, with that, let's open it up to public comments. Anyone want to weigh in on this? We've got a few different concepts here. We've obviously got just the logistics side of it, of how we implement the special purpose depository institution, and then the overall concept of the classification of digital assets. Go ahead, Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. Before we get started, Commissioner Forkner, could you talk a little bit about how your role has changed with your peers in regards to other states? I know we've talked about that in the past, and I do think it's a fascinating aspect, something that Ms. Janes has experienced in the Secretary of State's office. And it really, to me, is fascinating that our agencies in the state of Wyoming are taking on this leadership role, and other states are kind of looking at us like, what the hell are you guys doing over there? But I do think it's good. And can you speak to that a little bit?
Mr. Forkner, go
Mr.
ahead.
Chairman, yeah, Albert Forkner, Banking Commissioner. Yeah, to the point, it has changed. My world has changed dramatically. So I joke now that the community banking is so last year because thank God they're doing well. So no, but in all seriousness, for the last 3 years, I've mentioned this to the task force in the past that we're talking. I'd go back and meet regularly with the FDIC chairman and senior staff. We'd be at the board of governors around the table and talking about what's going on in Wyoming and in the banking space and how digital assets and cryptocurrency and all this is intersecting. And there was a major disconnect. The guy from Wyoming talking about this and how could this be? Fast forward to where we're at now. One, I can now go back and say I told you so, and so that's kind of fun, actually, a little bit. But because all the federal agencies are now having discussions that we were having, 3 years ago. That being said, the concept of like the SPDI or what we've affectionately dubbed Speedy Bank. So for yeah,
that's
absolutely.
good. Well done.
The conversations around that and what that intersection has done with our office is while an uninsured institution is not unknown to the state system, and the state system is often the institutions for innovation, and so that's why I'm a very big believer in the state's banking system and the dual banking system as a whole. But we're now dealing with topics that really other agencies, other state colleagues are just now beginning to scratch the surface on, and so. But what's also given opportunities to lead the charge in certain areas, not just on the legislative side. I've talked with and I can't speak for the Fed, but we've had conversations where they've been open to exploring what's going on in Wyoming, and especially Esther George, the president of the Kansas City Fed, is very appreciative of again the state system, and in whatever ways they can help, they've been willing to do that. But also, I think we're working on now what I will believe will be a nationwide initiative in the state banking system to have enhanced BSA, AML, KYC supervision over the banking system, because we have the ability through my state colleagues, and you've heard me talk about the Conference of State Bank Supervisors, which I formerly chaired. We have that initiative that we're starting underway, and that's right smack in our wheelhouse, where that will help not only, obviously the new industry, the new SPDI charter, but the banks that are more and more willing to entertain banking, crypto and blockchain related companies. There's still a lot of the uncertainty. We've heard that today about, okay, we need more regulatory and supervisory certainty in this space. I think this will give them the opportunity to have the conversations with the examiners, and the examiners will have the opportunity to ask the right questions that I think will open the door. This is just me speaking, I think we'll also have an opportunity to lead a nationwide shift in the view of banking crypto related companies, not crypto banking, but banking those companies in that space. Because again, it's much easier at the state level to come up with this, to be the guinea pigs, if you will, and especially a state like Wyoming, somewhat fly under the radar a little bit in that space, and that provides a little more regulatory clarity for our federal colleagues. Again, they are under the daily microscope as far as looking a certain way, maybe construed as a policy position, when in fact it's not. It's just trying to sort through some of the information. But nevertheless, I think that we do have an opportunity by having a heightened supervisory regime that may ultimately lead our federal colleagues, drag our federal colleagues along to recognizing the benefits and what that means for community banks. Because again, we have 5,000 banks in this country. 80% of them state chartered, so they're wanting to get into this space somehow if they can, if it's reasonable. And so I think we've got some opportunities at the supervisory space to do that.
Okay, follow-up.
Yeah, thank you, Mr. Chairman. So two things. Do you think the community bank aspect, do you think that will be achieved via the qualified custodianship rules that Wyoming set about?
No, Mr. Chairman, I don't think so. I think, at least not initially, that's a big lift. That's a really big lift, and there's a lot of resources that got to be dedicated to that. If you're, in an established, again, small community bank in rural states, I don't know if the incentive is there. I think where you'll see the first part is just the banking relationships for those institutions that are getting de-risked or have gotten de-risked, and being willing to entertain those relationships. You get the regulators willing to clarify, again, the expectation. That's the big question has always been, well, what's the regulator going to think? And if there's any sort of potential that I'm going to have, the banker, I'm going to have any sort of regulatory action, civil money penalties, then it's just not worth it. We'll just walk away. You get that regulatory certainty, the examination program, and you be able to have the questions answered. It makes it much easier to bank them, and not just on the depository side. Because again, these are, some of them are very big businesses, but some of those are startups, so they're small businesses. They need funding too. The lending function, that's we'll have to figure that out, and that's going to come from the traditional banking world. Again, maybe the bigger players look at Wall Street, but the smaller ones, traditional startup, and so you want small business financing. That's still a little bit of an uncertainty. What kind of relationship the regulator is going to have there. I think those doors will open, and we're seeing that now. Through CSBS, we have a bankers advisory board is just that. It's bankers that help advise the regulators on potential policy positions. One of the members is banks, some of the biggest companies that are known to all of us. They're in Chicago. They're downtown. They're a less than $500 million bank, which is in the grand scheme of things a very small bank. They're doing it, and so that kind of goes to my thought that as long as they're able to do it in a way that doesn't risk the institution, then it's going to open up. But I think we're giving some of that regulatory certainty out of Wyoming, and we'll continue to provide and pave that way.
Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. I appreciate the opportunity to kind of go back and forth because I'm essentially, so what I got from that is the biggest help right now for our community banks has been the FDIC relaxing on kind of their stance a little bit.
Mr. Chairman, that's probably a fair statement. I think I've said it before, people are policy. I think we've definitely seen a policy shift at the agencies with the new administration. Absolutely, and the dialogue that we have and the willingness to entertain conversations that maybe weren't there in the past. So that helps, but there's still a lot of things that, again, if we can provide some certainty, if we can show how this can be done in somewhat of our niche, which is the SPDI,
right,
you can extrapolate that out and benefit the broader banking community, I believe. So now to that point, Mr. Chairman, if I might, with this proposal on page 2 of the bill at hand.
One second, one more.
Sorry, Commissioner
Okay.
Fortner. You spoke about a timeline in regards to your organization looking at cleaning up or speeding up AML and KYC requirements. And can you speak to that timeline? Can I beat you to the punch with a bill? Could you give me a heads up on what that looks like so we can beat other states?
Well, not sure about speeding up what you mean. What we're doing is provide enhanced supervisory clarity and guidance. So
no legislation requirement.
That's a supervisory matter. If you want to try to amend the Bank Secrecy Act, I think that might be a good.
Did you say repeal?
Knock yourself out, Mr. Chairman. And get you some congressmen and let's talk to them. But no, all joking aside. No, what we're looking for again, and what we have the ability to do is how do we enforce that? How do we supervise it? How do we examine that? And so, because I definitely don't believe in supervising through enforcement, that is just not how we operate, and that's the policy position of mine that is not good supervision. And so, what you do is you supervise in the way in somewhat of a partnership, and you have the dialogue, and you give the clarity, and you're reasonable in your approach. And so, but we've got to know what to ask in this space. And so, the fundamentals of BSA, AML, KYC are there. The 4 pillars are really pick your industry. That's all the same. What it is the extra level of questions that need to be asked in the digital asset space. What's that next question? And so if we can ask that question, and then if we can also provide assistance to the banks as far as when they onboard customers, when they're doing their enhanced due diligence, what do they need to be asking? Can we help them build out a program that's acceptable to not only our office, but hopefully, again, the federal colleagues as well?
I guess just on a final note, Mr. Chairman, I would extend the same, and I've told you this several times, Mr. Fortner, and I know you get it, but I'll extend the same. As I've always said, if you ever find a situation where we can help clean up this situation and you need the legislature's help, know that this group of people will always be ready to jump on that situation because it is problematic for a lot of Wyomingites that are now starting to look at some of those issues. I mean, before, right, most people would open up a bank account like once or twice in their life, and that's it, which works well for a community bank. You go in, you sit down with your banker, bada bing, bada boom, you're out the door. But now we've moved into this digital representation space, and it is a painful animal when you're holding up a sign with your driver's license and trying to take a picture at the same time. It's I don't know if anybody else.
No, I know that's real. Yeah,
it's real. I've done it too many times.
Yeah, you're right.
And Mr. Chairman, I think in this committee has talked about it last year, and I think it's on the agenda maybe for tomorrow, some discussions, and the whole idea of digital identity, right? And what does that entail? And the abilities there. That is an extremely complex topic. I don't think that can be solved overnight, but it's definitely out there. And one of the benefits in the communities bank space if can be figured out and adopted, again, we're probably talking at the national scale. That helps with the KYC onboarding institution. So if I have some sort of verified, I am who I am, my background has been verified, I'm not a terrorist, I'm not doing this illicit activity, and you have that you can take with you into the institution when you're going to open an account, when you're going to get a loan, that can relieve the KYC, BSA, AML, KYC burden on them because they now have this. Now that's, like I said, it's easy said, but it's there's a whole lot of issues behind that. There's a number of ways to tackle that, and I think we'll have opportunities to explore that. I think it's more than a 1 hour discussion, but I think it's something that needs to be continually discussed. And then we actually had some conversation with the governor a few days ago, and he recognizes there's actually potential there as well. It's just we gotta, if we don't do it right, we can really screw it up. And so, but I think if we do it right, there's a lot of potential in that space.
No, you're doing fine.
Yeah, I'm sorry, I'm just really geeking out right now. So in regards to that, are you essentially, I'm not going to hold you to this, but I mean, the possibility exists that there could be third-party contracting or something like that with community banks?
Mr. Chairman, that's possible. I mean, like I said, there could be a way that you have this third-party institution. Again, this goes back to our discussions last year and tomorrow of this personal information trust. And the concept there is what can you do? Can you have an identity that you can, in essence, take with you and present your credentials, if you will, very easily? But then how do you protect that in the interim? Whether it be on the individual or the macro, the massive amount of data at the big box stores, or some of the social media outlets, things like that. There's ways to do it, which, like I said, it's we're getting a little off topic, but there's potential for that, and the spillover into the space that we live in is that could actually help community banks manage BSA, AML, KYC. And not have to have a whole host of compliance officers in order to bank a certain sector. But
Anything
there's a big
else
potential
on
to
this, or shall
fall.
we get to the digital representation
No,
tokens?
I'm going to quit, but
All right.
Mr. Chairman, I'm going to
Yes, sir.
apologize to LSO staff because I'm about to drop another bill request on you. We're just going to get it started.
Yeah. So, Mr. Chairman, if I might begin to keep us somewhat on
back
track.
to digital representation tokens.
Yeah, and so I think what Ms. Long said on page 2, we would personally have some very big concerns with this. I don't think an institution at this point yet needs to be issuing stable coins and whatnot, and it definitely, I can't speak for the federal agencies. I cannot imagine that would not have a very potentially detrimental effect on what we've accomplished so far.
Understood. All right. Any questions on that? Anything else you have concerns about with this legislation, or is that the big key? I think we're comfortable with that concept. All right. Any questions for Banking Division? Seeing none, thank you. All right. Further discussion, further public testimony on digital representation tokens? Any other agencies? Any general public testimony? We will be moving this forward to the next committee meeting for additional testimony. We'd appreciate feedback if possible with that. All right. Public testimony is closed. Back to the committee. Committee, any thoughts or anything we need to work through before we move this on to the next committee meeting? I think it's safe to say that as part of the draft we move forward, we'll strike the provision about the SPDIs, or the speedy banks, as apparently we call them now. Ms. Long. I know. Isn't it beautiful?
They're not speedy.
It makes me so much happier that it's called speedy banks. All right. Committee, nothing? All right. Go ahead.
Mr. Chairman, at the bottom of page 5, on the new language, could I request, since LSO is going to be bringing us another draft of this, that it look at the language in HB 62? I don't know if this works in our last year HB 62. I don't know if this works because we defined the 3 classes of digital assets as personal property already, and I believe that they are exchangeable, that utility tokens are exchangeable into the underlying property. So it's just a question for LSO, just to be sure that the language doesn't conflict. I don't know if it does or doesn't, but
Gotcha.
yeah.
So, Ms. Long, the concern is we're calling it property everywhere else, the token itself, and then we're having a clarification under the digital asset classifications that this one isn't explicitly property, that only the asset behind it is the property.
Yes, and we, in the Utility Token Act, I believe we made the token exchangeable for the underlying, because it was a consumer token, right? So you're exchanging the token for the digital access right or the like. So just want to be sure there's no conflict there.
Gotcha. Senator Nethercott, this would eventually come to you. Do you have any thoughts on what we should be doing for the next meeting? Any requests that you'd like to make so that you're more comfortable with it, or do you just want to think? All right, excellent. Committee, anything else? All right, so staff, I think for the next meeting then, it sounds like what we'd like to see is elimination for the next build, elimination of page 2, the special purpose depository institution language, and then on page 5, clarification of consistency with what we did in House Bill 62 last year regarding the classification of the token. Make sense? All right, we'll forward it after that. All right, moving on. Next topic for our consideration is real property tokenization discussion. And all we have on this actually is public comment. We don't have a piece of legislation. This was something that was raised for consideration. It's similar in some ways to representation tokens, but we've got some other ideas. And who was going to lead on this, Mr. Co-Chairman?
Yeah, thank you, Mr. Chairman. This, as you'll see in your pamphlets, this idea was brought forward by Mr. David Pope, who had a pretty interesting exchange with our LSO attorney, Mr. Shaw. So actually, if I could get Mr. Shaw to give us, would you be willing to give us kind of a synopsis of how that works out? Because my general feeling of that, after your deep dive, and you did a fantastic job diving into that. That's kind of the wild part of this blockchain task force is all of it's new and wild and crazy. But essentially, the way I read it is we can already do this. We just got to find a friendly regulator that wants to make that jump. Is that generally correct?
Mr. Shaw, what can you share with us?
It's correct, I think. Mr. Pope wrote the task force a letter. It's in your materials. It's dated August 6th. It does a good job of outlining the benefits if we were to find a way to tokenize real property and the way to tokenize the actual titles to that property and consider the transfer of tokens to represent the transfer of title to real property. We talked then a little bit about, okay, the benefits, the extent the benefits of doing that are clear. How do you actually get that done? And I have to admit, we did not resolve that in all its complexity because I think it's a pretty complex issue. But when I started looking at Wyoming law, I all of a sudden discovered that Wyoming has at 34-1-401, the Uniform Real Property Electronic Recording Act. And what that existing act makes clear is that the Wyoming legislature has already contemplated allowing electronic transactions in real property. What that act then does, it's fairly short, it's not very lengthy. I believe it was passed in 2016. And it requires ETS to promulgate rules for individual county clerks to use in using electronic records. The thing about the legislation that was passed is that while it certainly does not preclude blockchain, nor does it go far enough to require rules that deal with blockchain or otherwise direct how those might be handled. And so I did go back and I looked at ETS's rules, and they go a ways in allowing some electronic transactions. It talks a lot about electronic fees, paying fees electronically, et cetera. But again, certainly does not lay out a procedure for allowing blockchain. used or other method of tokenization of real property titles. So my suggestion at the time was to consider this legislation, and although again, it doesn't address the technical ways in which you would actually allow the tokenization of the title, there is clearly a process in Wyoming law for saying, hey, ETS, take a look at this. I did talk to Gordon Knopf, the director of ETS. I finally got a hold of him actually just on Friday, kind of gave him a heads up on what we're doing. They are looking at some blockchain things now. They are trying to be progressive and certainly are not sticking their heads in the sand in that regard. He acknowledged with me, though, that the lift might be fairly heavy in allowing this to happen. The way it looks like it would be now under the existing law is that it would not be mandatory but permissive among county clerks, which I think might be, given the different sizes of their staff, and might be important. So I guess without suggesting what the task force could, I guess I can only suggest what you can do. One option would be to have some legislation drafted that would direct ETS to further supplement their rules according to the existing act to allow blockchain to be used to file or tokenize real property records through blockchain. I think that I don't know that if they would or would not request some manpower or money to do that. They probably would need some expertise and at least a fair amount of collaboration to figure out how to accomplish that task. One of the issues that I contemplated is this basic question about, and I think it's a very technical question, and the task force should think about, does tokenization of title and how it relates to real property records with county clerks, does it mean that the county clerk maintains a blockchain upon which those tokens are placed, or does it mean that the county clerk is going to use other people's blockchain for purposes of proving title? And I think that's an important distinction. I don't have any idea what the answer is, but I think those are the kind of distinctions that need to be made if we want to.
Excellent, and excellent work on that. Thank you for the follow-up. I really appreciate it. Go ahead, Mr.
Yeah,
Chairman.
Mr. Chairman, for those that missed that discussion that shook out, it was a deep dive by both sides in regards to this question, in regards to Mr. Shaw and Mr. Pope. And it was fascinating. I did not enter the fray for fear of tripping over my own feet. But it was a really good conversation. And I tend to agree with Mr. Shaw after looking at the titles that affect this and how it currently works. I mean, we could run a bill that says, hey, ETS, update your regulations. Or we just sit down with ETS and say, hey, what do you think about this? And I think that's probably the more prudent choice right now.
Go ahead and ask the question.
Mr. Co-Chairman, perhaps I missed it in the explanation, but I don't understand what ETS has to do with it. One, and two, I share the same kind of challenge in understanding the concept associated with who creates the token and when is that created. And then if he wanted to own, I recognize in the letter it indicates that the property is held by tenants in common, but would you also be able to hold it with joint tenants with rights of survivorship or tenants by the entirety? And if so, what do those tokens look like, and how are they issued, and who issues them? I think there's a lot of questions here that conceptually I need answered.
Thank you, Senator. Ian, will you go back over the ETS involvement real quick?
Sure, Mr. Chairman. It does, the act itself gives various definitions. It declares the validity of electronic documents by saying that anytime there's an original or a paper writing, then an electronic document can substitute for that. A signature can be substituted for electronic signature. Notarizing, witnessing, and acknowledging documents can also be accomplished electronically. So it sets out, those are all terms that are used in the property records for titling. And so it basically says, okay, now you can do that electronically. Then it says ETS, is going to promulgate rules that will allow county clerks to accomplish that task. Then it includes some other things like paying fees electronically, some other things. Very broad legislation. It clearly contemplates things like blockchain and the use of electronic transactions. But again, it's very broad in its authority to ETS to simply promulgate rules that would go to that purpose.
Will you remind us of the year when we passed?
In 16.
16 was when we did that one, okay. Go ahead, Senator. Nope, all good.
Mr. Chairman, One other thing, I don't know if this, when we're talking about the statute itself, I would suggest that if the task force were going that direction and wanted to get ETS to do this, the existing law is broad and likely adequate, but it does odd things. Like it never actually says, although it contemplates that it's being done, it never actually says that these electronic documents can be filed as the property record. For example, and I think that kind of clarity, there are some things that, and Mr. Chairman, if you want, LSO can just go through this and do a fairly simple draft that might propose some of those things for the next meeting if you want. But I do think this legislation itself could be made a little more clear, even for its existing purposes, let alone for the purposes of tokenization.
Mr. Ian, you said that's not too much work. That's my biggest concern. Okay,
that's
because
right,
we've got
Chairman,
1 month.
That's right. And I also don't, LSO is reluctant to do policy, as you know, but I don't think it's really policy. These would be fairly simple amendments that just make clear that, for the purposes, for example, tokenization.
If we just want, if what we want to do is make it so that it works for tokenization without any question and properly affects that, I think that's a reasonable thing for us to take on, particularly since it's then relevant to tokenization. We can do some cleanup, and that's a good idea. But I'm just sensitive to not taking on too much, since we don't want a lot of new drafts for the next.
Right. Mr. Chairman, that wouldn't be hard for us to do.
All right.
And trust me, though, the devil will be in the details later on when ETS has to decide how to implement.
And we'll make sure that if we move forward that way, that we'll bring them aboard for the next committee meeting. So that's one option for us. Committee, any other discussion before we go to public comment? Senator Nethercott, did you have anything?
Yeah, Mr.
Go ahead,
Chairman.
Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. I think if we do move forward with that draft, I mean, the ideology would be to ensure that it's permissive, A, and B, that it actually is essentially a cleanup piece of legislation that is going to the intent of what the original statute says. I mean, that's the way I understand this. And if that's the case, and it's not going to specifically mention blockchain or anything like that, or tokenization, it's just a cleanup for the permissive, I don't know that the blockchain task force can actually sponsor it at that point. It might be good to look at, and then an individual legislator could sponsor at that point. But I just worry that we come forward with a bill with no mention of blockchain in it whatsoever. We might have some folks go, well, why are you even doing this? So I guess that would be, something to think about.
Right. And we can certainly make it clear that the blockchain aspect of it is enabled, where there was some question, but you make a good point. Other discussion, committee? Yes, go ahead.
I might add one thing to that. It's possible, as well as creating, and I think it could be done in a single bill and a single subject, would be to draft a legislation that cleans these provisions up for the purpose of allowing things like tokenization, but that at the same time you could insert a non-codified section that asks ETS to update its rules to allow blockchain tokenization of real property titles. Again, I think the secret for the task force would be to, I don't know if they're going to ask for resources. I think they're going to need to get that done. I imagine they're going to need to collaborate with industry. I mean, it's not just as easy as saying they need to do it, because I think it would be difficult, but that could be included in the bill as well if that's the task force desire.
Okay. Anyone from ETS policy here? I know we have ETS here. Are you prepared to comment? Okay, but you're looking forward to commenting at the next meeting, aren't you?
Mr. Co-Chairman?
Yeah, go ahead.
I don't know if we can have ETS stand up and maybe come forward.
Sure. Come on up.
So not having the statutory section in front of me regarding your ETS's creation and what you're supposed to do, is this even appropriately placed within ETS? It seems very absurd to me that it's within ETS at all. And so that's probably why there's no rules and regulations that have been promulgated, because not really your wheelhouse. Is that fair to say?
And please identify yourself once again, since you're on mic.
Ray Brand with ETS, Enterprise Technology Services, State of Wyoming. So I can answer that with my opinion, because it was kind of assigned to us by the legislators. I personally didn't think it fit within our wheelhouse, but the logic was ETS already had electronic signature, and the rules were written in such a way that it meshed with electronic signature already from the uniform code writing. And so that's where the initial logic was that I understand.
Do you think that this should still be within ETS, or should we pick another more appropriate state agency potentially, if one at all?
Go ahead, Ray.
Oh, Mr. Chairman, I would have to talk with our CIO, Gordon Knopf, on that.
Mr. Co-Chairman,
Go ahead.
have there been conversations about following the legislative mandate to promulgate rules and regulations? And if so, what do those look like, and why are they not done?
Right.
Mr. Chairman, there were initial rules that were written, but they were, in my opinion, written loosely. I mean, could they be written more appropriately and firmly? Yes. I mean, we had a recent change in leadership, so I mean that's part of the reason why that would show that we haven't addressed it at this point.
Follow-up, Senator.
Committee, let's think of a more appropriate agency that makes sense as opposed to ETS. Just because ETS does stuff with computers doesn't mean ETS is the right agency to house and deal with real property records and the tokenization thereof of property interests.
That's probably fair. Co-Chairman, go ahead.
Yeah, thank you, Mr. Chairman. Off point, I do want to commend Mr. Brand. He is diligently at all of these committee meetings and taking notes, and I know ETS has done a lot of work in regards to blockchain in the last year in your own shop. So that's kind of an interesting aspect, and I thank you for being here.
And for the next meeting, let's have that as a question. Senator Nethercott's concern, should it be with ETS? Should it be elsewhere?
Yeah,
expect a good
because I think fairly, I think I'd like to have our CIO Gordon Knopf share his thoughts on that.
Absolutely.
Yeah.
And it may be, but I do know that when we first set up ETS, it was not supposed to be a policy shop. It was supposed to be a supportive shop that didn't have kind of the policy role, and then we've kept things on over the years since that point and effectively changed it. Have that discussion. Senator? Anyone else? Thank you very much for your testimony. Look forward to seeing you next time.
All right, thank you.
Yeah, does any agency actually want this? Looking at you, Secretary of State's office. Yeah.
I didn't say that. I didn't say that.
All right. All right. Any further public testimony on this topic at this time? Yes, come on up. Again, please identify yourself for the committee.
Mr. Chairman, my name is Emma Channing. I represent Consensus. My words are my own. While not wanting to push the issue, earlier on this year, Consensus did do a proof of concept tokenization with the Majesty's Land Registry. We're very happy to provide, laws kind of similar.
Right.
So very happy to provide resources such as LSO needs, but this is definitely there.
Excellent. Sounds good. Thanks. Any questions for Ms. Channing? Yeah, go ahead, Mr. Chairman.
Thank you, Mr. Chairman. Ms. Channing, thanks for being here once again. In regards to Consensus and what you're doing, we've actually had a pretty fascinating aspect shake out with one of our counties who put all of their land titles on a blockchain. I'm sure you're aware of what the Medici Group did. And it was kind of one of those partnerships. Can we do it? What does it look like? They came in, they did it. It's cool. Would Consensus be interested in participating in something like that on a strictly volunteer basis if there was a county that was interested in participating?
Go ahead, Ms. Channing.
Well, obviously, I can't speak on buying Consensus. I'm sure we'd be very interested to explore anything like that and or provide something that is open source and builds on existing efforts.
Great. Ms. Channing, will you look into that for the next meeting, and hopefully you'll be joining us? I assume you will in Laramie. Expected as much. So let's have that conversation in Laramie.
One follow-up.
Go ahead, Mr. Coach.
Yeah, thank you, Mr. Chairman. I just can't remember. Is Consensus sponsoring part of the hackathon?
Ms. Channing.
Co-Chair Lindholm, it's very kind of you to mention that Consensus is indeed sponsoring the hackathon, and we'll be doing an NFT challenge as well as some burner wallet demonstrations.
And we look forward to it. Thank you. Anyone else? Committee? Oh, my apologies. Representative?
At some point, I'd be interested maybe to hear from the Sheridan County Clerk and Recorder, who's also here. Maybe
that would be great.
Weigh in if they so choose.
Sounds good. Thank you. Thank you, Ms. Channing. So we are open to public testimony. I think that would be a wonderful transition. If you'd like to join us up at the table, introduce yourself once again to the committee, and welcome to the Blockchain Task Force.
Thank you, Chairman and Representative Western. Ida Shunk Thompson, Sheridan County Clerk and Recorder. This topic is near and dear to my heart. The history of our land and our people clear back to prior patent. I mean, it's a wonderful history book and a huge responsibility and something that we all take very seriously as county clerks, as one of our many hats that we wear. Sheridan County, I can speak for that. We are e-recording, as we call it. And I'm here today to learn the terminology and the language. Everything from Bitcoin to everything else is all new to me. So I'll just be honest with you right up front. This is something that I'm learning about. The letter here I found very interesting from Mr. Pope. And it brought a lot of questions to my mind and something that I'd like to take back to my Clerks Association. We are meeting in September. It'll be the week right after your next meeting, unfortunately, but we are meeting for Waco, and we'll be meeting in Casper. So I'd like to share this with our current president, Crook County Clerk, and come back with some feedback as an association for this. But,
and will you send us the details of the dates of that meeting? Maybe somebody would be available to join and discuss.
That would be terrific, and I'll have our president contact your task force group.
Wonderful. Mr. Co-Chairman, go ahead.
Yeah, thank you, Mr. Chairman. Madam Clerk, thank you for attending. Really appreciate it. Always appreciate the clerk's presence. You guys have been involved with the Blockchain Task Force from the very get-go with Clerk Daigle. And as you know, or you probably know, Teton County is now all on a blockchain. So kind of a fascinating aspect. And I'd really like to hear back from the clerks whether or not a county would be interested in participating in something with a joint venture with a private organization.
I'll be happy to take that back to the association.
Thank you.
Wonderful.
And just speaking for myself, I'm very interested in the security side of this, working with the Secretary of State's office and our State Fusion Center with elections, and knowing that cybersecurity and security all the way around is the topic of discussion. And again, when you talk about property records and personal information, all of that, it goes hand in hand. Thank you.
So I have one quick question, maybe somebody else does also, but you said that you have an e-filing system right now, effectively. What are you storing? What is the electronic content that you actually have, and how do you store it? Is that in your own database, or is that external?
Mr. Chairman, Sheridan County works with a vendor who works with other vendors. Our current document vendor has agreements and working background with e-recording vendors who specifically work out those agreements. Our county attorneys review those agreements, the protections in place, the expectations, the custodianship of the document. Those are received in an e-recording. It's a module. It's part of the recording department where they are transmitted electronically. A window pops up, tells us we have a package. We go to our window on our computer, open it up, review it. If we're able to accept it, that it's properly named, it in fact belongs to our county, the legal description fits, etc. We already have the parameters set up with our e-recording vendors. So a lot of the homework is done ahead of time. A lot of planning and work goes into these vendors. This is what they do for a living. The vendor then takes care of the fees, the statutory fees, and makes sure those are deposited correctly. The fee that they make being the vendor, e-recording vendor, and then the fee that the county clerk collects statutorily. We can't collect more than what statute allows, but is a well-run operation. And again, we work with a vendor who works with e-recording vendors who have contracts and agreements and have the details worked out.
And is there no paper along the way? Is there any sort of paper trail, any redundant paper, anything along those lines? Is the entirety of the transaction electronic from beginning to end?
It is electronic from beginning to end. We also, once we accept that document, it is immediately receipted back to the person who submitted it. They have all their recording information almost instantly once it's reviewed. They have the date, the time, the receiving number, if there's a book and page assigned, so it's all electronically done that way. Individual counties then choose to actually, if they're still writing in a book, a track book, and if they're still photoing that into a hard book that can then be pulled. In other words, each county is still deciding whether or not to, in addition, have a paper trail with a track book and the document as well.
And who holds that data? They hold the data remotely? The vendor that you're working with is holding the data?
No, the clerk does.
You're holding the data.
It comes into our database.
Okay. And now that's in the details, but I was just curious about kind of the backup and security side of that. We'll talk about that. Go ahead.
Are you reselling the data, and is it searchable? I know some of the counties are putting it up for different vendors to be able to do it. Are you guys doing it, and how many counties might be?
Ms. Thompson?
Chairman, Senator Driscoll, I can get that information for you on which counties are doing that. For Sheridan County, I can tell you that a module that I have supported is a hosted site by our vendor where people can go in and access for a fee, a copy, a search. They can search by day, a week, a month, a year, and do that electronically. I'm limited in how far back that can go. And for Sheridan County, that's only through back to 2010. The county does not have the resources or the money to digitally archive all the way back to territory time.
What would that cost? Have you done a cost estimate?
I don't have a cost, no.
Mr. Chairman,
Oh, I'm sorry, follow up, please.
Would a vendor be able to come in and access that for free? I know we can get to the books, but would the counties allow a vendor to go back in on these old records and access them for free?
In Sheridan County, you can walk into my land vault and look at any record all the way back at no fee. We have companies that come in and take pictures. Some companies come in and scan data. It does vary from county to county. I don't know that I can confidently speak for any other county but Sheridan County on that question.
Thank you.
Any follow-up? Mr. Co-Chairman.
Yeah, thanks, Mr. Chairman. And just to roughly guesstimate, I've had these conversations with my clerk Fritz, in regards to going 100% digital and digitizing all those records and what that looks like in cost. Several counties have done it. Most have not because of the issue of not having enough resources. We actually looked at what that would cost, and the state could supplement. And it would cost for Crook County, I can't say for everybody else, but for Crook County and what we expect as the average is right around $30,000 to $35,000 per county. It's not a whole bunch because essentially you're hiring somebody to temporarily come in and scan records and scan records and scan records.
$1 million.
Right. So that's essentially, and it might be worthwhile in the future for the legislature to look at to offer our clerks the ability to hire some outside help to come in and do that.
Mr.
Additional
Chairman,
discussion? Yeah, please.
Representative, may I respond?
Yes, you may.
Sheridan County did look at our legacy books, and we did archive our legacy books. And when I talk about that, I mean books prior to computers. We had historical green ink and a lot of handwritten documents. And we actually were not able to use traditional scanning in methods. We had to hire through pictures, photography. And that cost to the county was $500,000. And so it can depend on the number of records that you have, how much activity you've had in your land departments, and what type of documents you're looking at archiving. And if you're dealing with green ink, that's fading and a photograph is better than the original, and those are all things to consider.
I believe Co-Chairman Lindholm would have sat at his computer and done it for you for $4.95, if I'm not mistaken.
Mr. Chairman, that's
Yeah,
correct. I would have
yeah.
purchased the camera, whatever you wanted, driven to Sheridan every day.
Well,
Would have been
lost
great teamwork.
Opportunity
Next time,
lost.
maybe.
Thank you so much for your testimony. Appreciate it. Look forward to working with you. Any further public testimony on this topic? All right, this will be moved forward then to our next committee meeting. We have the opportunity to consider creating this draft. Mr. Co-Chairman, what are your thoughts? Should we get this drafted or?
Mr. Chairman, I think the bigger issue that was brought up is we don't even know, where we should find out if this is even in the right wheelhouse as it stands before we move forward with draft legislation. I do think it is an easy cleanup, and it's something that I think the legislative members of this task force should keep in mind, and as a possible individually sponsored piece of legislation. Once we hear back from ETS, I would be more comfortable with supporting that direction. But as it stands, this being our second meeting, and we're not even sure if this is already going to the right agency. And my opinion is to hold back.
Okay, so we'll have a conversation about it at the next meeting, and we won't have anything drafted this time unless there's objection from the committee. Seeing no objection, Ian, understand? All right, excellent. The next topic, and the last one of the day, digital identification discussion. This is a topic for today, but we don't have Representative Yin here. He was going to be the one who introduced it. We don't have any legislation on it at this time, and we're actually going to have a demonstration along these lines in September. So I'm inclined to take public testimony at this point in time and see if there's anybody here who wants to weigh in, provide public testimony on digital identification, but I don't know what other action to take at this time. So I'll open it to the committee first to see thoughts on what we should be doing with regard to digital identification today. We can provide a little opportunity tomorrow once Representative Yin's here. Ms. Long, I see your light's on.
Thank you, Mr. Chairman. Two issues is one, we heard testimony this morning regarding the SIM swap. I wonder whether we should be bringing that up. And then second, I've had a conversation with your co-chairman about an issue that I've personally encountered, which is that seemingly the Bank Secrecy Act requires identification using a physical address. And a lot of people in Wyoming only have a P.O. box and do not have a mailing address. And this is an issue. The folks on the coast can't imagine that a P.O. box is your only address. But if that essentially means that you're going to not be able to open an account at a financial institution, that's a way of keeping rural folks from having access to the financial system. And my understanding from my own digging into it is that it relates to the travel rule and recent regulations that have just been implemented. And so there may not have been a significant amount of complaints coming from Wyoming citizens yet, but because the banks have not had the requirement to go through and cull their existing customer list and get a physical address from existing customer lists. But if the physical address isn't one that's recognized in some national database, all of a sudden it creates an unbanked problem for rural people. So, Representative Lindholm?
Go ahead.
Yeah, thanks,
thoughts?
Mr. Chairman. I've actually ran into this issue myself. As a lot of you know, I live out in the sticks, like way out in the sticks. And so I have a P.O. box. My little 26 Windy Way is not recognized by USPS. Where I ran into the issue was a friend of mine, his father wanted to get into crypto. Super pumped about this. It was kind of a wild ride, I'm not going to lie. So getting him signed up for different accounts, getting him going down that road. And one of the biggest issues that we ran into is that his address is also not recognized. And so that one of these companies use the USPS because they have to verify KYC. And his address does not show up. He's got a PO box like the rest of rural Wyoming. So it is an issue when we're talking about rural folks, and which is most of Wyoming. So something that definitely should be handled. I don't know if the Division of Banking wants to wade into this one, but it is an issue. Actually, you know what? I love Commissioner Faulkner.
You want him to come up? Do you want to call him up here one more time? Yes, Commissioner Faulkner, would you join us up front while we discuss this issue? All right, nothing to comment on. We'll get him next time.
Mm-hmm.
So, on that topic, I guess one question is, what can we do? Well, we can. It's federal law, but we could send angry letters saying, "Give this some thought." I want Senator Nethercott to write it for us.
I will note for the senators that some of those letters that we did send in the last committee meeting were very effective in achieving what we wanted to achieve. So I used to be that person that dismissed a lot of those letters, but they can be effective if done correctly.
Go ahead, Senator Nethercott. You want to say that on the record? No? Okay. Yeah. All right. Anything else on that topic? I think it's a good one for us to consider and address it. Okay. Anything else, committee, with regard to digital identification discussion for today before we go to public comment? And again, I think we'll bring this back up tomorrow when Representative Yin is here to talk about what the working group has done. Nothing else from the committee? All right. So going to the public, and again, we'll raise this tomorrow. So I'll invite public comment on this topic, but I'll also offer the opportunity tomorrow. So if you're going to be back tomorrow and would prefer to provide public comment tomorrow, I think that would be just great to keep us on schedule, but I would open it now, particularly for those that have traveled. All right. Seeing no public comment
Mr.
on that.
Chairman, there is a kindler, gentler chairman at the wheel right now, whereas tomorrow that chairman is
yeah, he's rogue. It's off the rails a lot of the time. We don't know what he's going to do.
Yep, nope, that's a fact. So, just a thought.
Take advantage of it while you can. Choose your chairman.
Choose your chairman.
All right. Seeing nobody coming forward, we'll close public comment on that. Committee, does anyone want any more action or any more discussion on digital identification today? Again, we will raise it tomorrow. Tomorrow, it sounds like from Senator Nethercott, who we're ahead of schedule, and she still wants to hurry me up. All right, at this point, I would open the floor for any public comments on any other general topics, particularly for folks that won't be here tomorrow. We will again have public comment opportunity at the end of tomorrow if you'd prefer to do it then. That'll include ideas and suggestions, other areas for legislation, things that we haven't been talking about that we should be talking about, all of those types of things. All right, seeing none, public comment is closed. Back to the committee. Anything else that we need to address today? Staff, anything else that we need to address today? All right, with that, we are adjourned for the day. I'm afraid you're going to have Representative Lindholm, the Co-Chairman Lindholm, tomorrow, so I bid you adieu. Adjourned for the